Testing, 1 2. Testing, 1 2 1 2. Test on my see what it sounds like. Sure.
Testing 1 2. Testing 1 2.
Testing, testing. Testing 1, 2. Testing 1, 2, 1, 2.
2026, and the time is 9:05. Thank you for all attending the Peace Officer Standards Accountability Advisory Board hearing. Please note that the hearing is being live streamed, recorded, and transcribed. Further, please note that the microphones are auto on off. When speaking, they will go live. With this, you will need to watch crosstalk. We will now call the roll of board members.
Thank you, Vice Chair Doyle. Clavo. Present. Crawford.
Present.
Doyle.
Present.
Dudley. Johnson.
Present.
Lara. And Pena.
Present.
Thank you. The quorum has been established. On my left is Post Counsel Chris Beatty, and on my right is Post Assistant Executive Director Anne Marie Delgado. First item is public comment. The time is set aside for members of the public who wish to comment on items not on the agenda, but those within the board's jurisdiction. Public comment on matters on the agenda will be heard after each item is presented. Public comment on specific peace officer revocation cases to be heard today will be heard at the time of the hearing of each matter. Is there anyone present in the audience or remotely who would like to address the board in public comment? Okay. Please be advised that the board cannot take action on items not on the agenda and may discuss those matters only to the extent necessary to determine whether any matter should be made an agenda item at a future meeting, to respond briefly to statements or questions posed, to request clarification, or to refer the item to staff. Please remember that this meeting is being transcribed, so I may politely interrupt and ask you to repeat or speak slowly and clearly so your comments can be correctly captured in the transcript. As the board's vice chair, I may ask members of the public to limit their remarks to no more than 3 minutes pursuant to existing board policy. I may conclude the public comment period if multiple speakers are voicing repetitive or similar statements and that the 15-minute public comment period has expired. You will be given 2 minutes to speak, and the time limits will be strictly enforced. So please ensure that you complete your thoughts within the allotted time. Before I open public comment on the matters not on the agenda, please note that if you wish to comment on disciplinary matters scheduled to be heard today by the board, you must wait until that matter is called to offer public comment. If you have a specific complaint about an officer that is not on today's agenda, you should file a complaint with Post or with the officer's employing agency. Post staff will assist you in that regard. I would like to remind individuals making comments not to discuss pending complaints or pending disciplinary actions that may later come before the board. A recommendation: if the opportunity to address the board at the time allows these rules, is necessary to comply with the law and to avoid compromising board mission. When it is your turn, you may state your name and organization. So we'll open it up to public comment. So anyone in the audience who wishes to address the board? Please.
My name is Ada Kitchen. My name is Ada Kitchen. I'm the grandmother of Stephen Taylor, who was murdered in San Leandro.
Yep.
Okay, thank you. My name is Addie Kitchen. I'm the grandmother of Stephen Taylor, who was murdered in April of 2020 in San Leandro. He was in a mental health crisis at the time. And my question is, how do I start to apply for a decertification from the officer? How do I know that the officer is still certified? And is there someone here that could help me to start the process?
Yes, thank you so much. We have members of our complaint intake team who can help you to file that complaint, register your case with with our division. That would be investigated and we would be in contact with you. So as you go back to your seat, a member of the team will come up and get your information and help you with that process.
And can you tell me how long does that process?
It depends on how long the investigation takes. It depends on the complexity of it, how long it takes for us to get records from the agency. It can take anywhere from 6 months to a year.
Okay, thank you. I think that's the only questions I have.
Thank you so much.
Thank you.
Good morning. My name is Arleta Nance, and I am the mother of Tamar Wilson and Thomas Wilson Jr. On August 18th, 2023, my son Tamar was shot in the back of the head and killed by the Martinez, California Police Department. And my son Thomas was shot twice in the back and survived. After being shot, my son Thomas was also assaulted by officers. Internal Affairs conducted an investigation into this case and found misconduct serious enough to warrant the termination of multiple officers. The findings included excessive force, failure to report misconduct, and conduct that reflects abuse of authority. These are not minor violations. These are categories that fall directly under POSAD definition of serious misconduct. In November of 2025, I filed multiple complaints with POSAD and received confirmation that they were accepted. Those complaint numbers are public -25 -001-465, 001-466, 001-467, 001-468, and 001-469. I have not received any meaningful update shortly after filing those complaints. So my question is simple. If these findings meet POSAD's own categories for serious misconduct, what is the status of these cases, and are they being reviewed for decertification? And did the agency meet its obligation, which Martinez agency, they were obligated to report the misconduct to POSAD within 10 days? Impacted families deserve to know whether this process is working. And if somebody could help me with information, I've sent emails, follow-ups, and I've heard nothing back. Left messages on the recorder because you can't talk to anybody when you call, and it's been since November. So
Certainly, thank you for your comments, and we will have someone get in touch with you. There's members here that can reach out to you and give you the status of those complaints.
okay, thank you.
Thank you.
Good morning, everyone. My name is Catherine Wade. I'm the mother of the late Malad Raynell Baldwin. My son was assaulted many years from Antioch Police Department. And in 2023, the FBI and the district attorney performed an investigation in that department, and they text about the sexual assault that happened to my son. I'm here today because I've submitted many complaints over the years, and I just found out about POSAD, and I would like to see if I can get an investigation or get some help. Of what they did to my son. He never got a chance to tell his side of the story, of the stories of the things that was happening to him. And I have a question too. Do you accept complaints of the sheriffs who are the acting coroners?
Yeah, so POSAD has jurisdiction over any certified peace officer, so that would include sheriff coroners as well. Yes, ma'am.
Okay, well, I'm here today because I need some help on getting this information to you all that I have to see if I can get some help in an investigation on the things that was done to my son. and even the admission in the text messages that they text about him. Thank you.
Have someone reach out to you here today that will help you with the process, okay?
Okay.
Thank you so much.
Good morning.
Sir, can you hold on one second? I'm sorry. I just want the record to reflect that Board Member Charles Lara joined the quorum so that we have that on record. Thank you, sir. Go ahead.
Yes, ma'am. Thank you. My name is Aaron Bluford. Alan Bluford's brother from the Alan Bluford Foundation. My mother is Geraldine Bluford, and I'm here to speak on the impact that it had on me and my family's life. I didn't know we couldn't use the speech that I had, but May 6th, my younger brother, Alan Dwayne Bluford, at 18 years old, had 2 weeks to graduate. And before we could see that milestone and have that whole feeling of seeing your son, your brother, your family member go and graduate high school, he was killed by an officer that did other things and were sent from another state, had violations out there, did something to my little brother. He passed away tragically. It tore apart my family. And he was able to, again, go and do something else to somebody else. And this is on record. At 10 years old, Alan Bluford was killed. After that, his mother went through health problems. Father went through health problems. Lost my grandmother, lost my aunties. It just was so traumatic to my family and each family that experienced something like this, who had to face identifying a son or their brother and living with that and seeing that for the rest of their life. My mother's been speaking. She's been in DC. We've been pushing forward with the Alan Bluford Foundation, and I wrote something. I wrote a little something that I feel like everybody could value and hear, because we all have a family. We all have people that we love, and this should be understanding and heartfelt. So before time runs out, as tears wear our eyes, while families endure a pain that doesn't subside, when hearts have spoken, let their voices be heard. As the faith in each name stands in God's glory and mother's love and nature of our nourishing, let each word be heard. Every life, every testimony, for each hour of each day facing a reality with memories of tragedies. Living in one nation under God, let their voices be heard as we stand in solidarity. Let their voices give clarity and brighter possibilities as the light of our eyes first came from the love of a family. I'm here representing the Alan Bluford Foundation, and I just want to make sure that everybody's heard that in this situation, and we can make for a brighter future, more possibilities to where this doesn't have to keep continuing and happening. Mothers don't have to keep appearing in front of you in tears we could work together. What we have in front of us, we're here in solidarity. And I thank you guys for this time. Alan Bluford was such a pivotal person to my family. And when I lost my brother, I lost so much more. And it doesn't subside. And if we can communicate and agree that we can have a better future for how this is looked at and gone about, I think that's a part of that dream that everybody been speaking for the last 50 years. I thank you for your time and your service. God bless.
Thank you. Is there anyone else in the audience that would like to address the board? Seeing none. Is there anybody attending remotely that would like to address the board? No. Okay. Next item is approval of the meeting transcripts from February 5th, 2026. Is there any discussion? If there's anyone present or appearing remotely or by phone who would like to address the board regarding the approval of the February 5th, 2026 hearing transcripts. Seeing none. Any board members like to comment on the February 5th, 2026 hearing? Seeing none. Is there a motion to approve the minutes?
I make a motion.
Second. We have a motion and a second. All in favor signify by saying aye.
Aye.
Abstained, so I was not in attendance. At this time, Post Assistant Executive Director Anne Marie Del Muno would like to address the board and introduce some of the new business items.
Good morning, members of the board. We have a statistical data profile report that we've had before you at every meeting we've had. We are not going to go in depth over each of these slides because this is just a quarterly update. However, we do have some additional information on the public complaint receipt and process in response to questions you've had at prior meetings in terms of how long does it take, how responsive are law enforcement agencies when we get a public complaint that we either do not have a agency misconduct report that's already been filed. What is the timeline for that response and what is happening with those complaints? So Bureau Chief Sarah Wallace is here to provide you with just a quick verbal update on that, and then we'll take any questions you have. Thank you.
Good morning. Based on questions received over the last several meetings, my Bureau Intake and Disposition went back and we evaluated how we could fine tune the data that's being presented. We are still in the process of fine tuning that, but I have some preliminary data that I'd like to share with you today. We took a sample size of 304 closed complaints, public complaints, out of a total of 1,450. This was a total back in March. That would provide a 5% margin of error. Of the 304 public complaints, 33 agency misconduct reports or agency supplemental reports had been received prior to the receipt of a public complaint, which is approximately 11%. Approximately 71% of those complaints received an agency misconduct report after the filing of the public complaint, and 18% of those complaints resulted in a closure due to the complaint being duplicate, non-jurisdictional, or the complaint was created in error. We found that the average time frame for an agency to respond to a notification of public complaint was approximately 80 days. The average time frame for an agency to provide final findings of a public complaint was approximately 67 days. And once our agency received the agency's response, it took us approximately 127 days to be able to review and make a move, either close the case or move it on to the next step. You've seen in the statistics some additional information, but I wanted to provide a quick breakdown. Of the closed public complaints that we have received, 2 of those public complaint cases resulted in a voluntary surrender of those peace officers. 1 public complaint resulted in an immediate temporary suspension. 8 of the public complaint cases were categorized as priority 1 cases, Of those 8 cases, 5 were closed being due to them not being serious misconduct, and 3 were not clear and convincing. 4 of the public complaint cases were labeled as priority 2 cases. Of those 4 cases, 1 was not clear and convincing, and 3 were not deemed serious misconduct. The bulk of our public complaint cases are priority 3 and have been closed, and 8 of those public complaint cases were priority 4, meaning that they were not actionable, and those were closed. We are still continuing to fine tune this and looking at additional data points to provide you additional insight into our public complaint process and the response that we're receiving from our agencies. As always, we continue to follow up with the agencies. We work collaboratively with our professional conduct bureaus to make sure that they have the information they need to be able to review their public complaint cases and reach their final determination.
Sarah, any questions on any of that data? Yes, Board Member Crawford.
Hi. I guess just as most people want to know, we want to see the timeline. Is it somewhere posted on the website?
It's not currently. It's something that we're evaluating whether or not we're able to do that based on the data entry points that we have in our case management system. It will be something that I'm hoping to be able to provide in our statistics moving forward, and those would be publicly available on the board meeting materials. But it is something we're evaluating.
Okay, so I guess, because you mentioned the date, timeline, like one of them had 80 days, even if it's something generic, because I think what the public is looking for is transparency, something that is tangible in a sense that they can look at and say, okay, they have 30 days to reply, 60 days to reply, something generic to give them some pinpoint motions. Because, I find myself in my community that I have to say, you do know you can file a complaint with post. You do know that if you file also with the agency, you still have that option. And so in my community, I push post as well as filing complaints with the officers. And so if that's something, maybe we can look at, I'm not asking for, but just something generic to pinpoint some type of timeline so the community can be able to see that this is what's happening and maybe, it fell off the grid somewhere.
No, I agree. I think that's valuable information. Again,
you.
I don't know that the average, I think we need to provide additional information more than just the average and show the median as well, because you can have an anomaly of a long response that can throw the average as well. So we're still working on it and trying to provide as much information as possible. And we'll continue to work on it and come back to you with additional info.
Thanks, Sarah. And just to be clear, we do have some reported and posted timelines. On page 5 of your statistical profile, these are the average timelines for all cases, not just public complaints. So Sarah was providing details regarding complaints that came in from the public, not that came in from the agency. So we have those averages for all, 45,000 that come in.
On the website?
It is, yeah.
Okay.
Yeah.
That's all. I was looking.
Yeah, thank you. Board Member Johnson.
For more clarity, under public complaints that are filed before the agency actually files, I thought I heard that sometimes the public complaint is a duplicate of the agency complaint. And when you come across that, you make a determination on removing one of the complaints since it's a duplicate. How do you make that determination whether to remove the public's complaint or the agency's complaint if they're duplicate?
It wouldn't be a duplicate from the agency or the public complaint. It would be perhaps a duplicate copy of the public complaint. So those are typically loaded into the same case jacket, same case number, so that you have that information available with the agency response that you receive. We're just not counting that public complaint twice. The information's still available in there. It's counted as a consolidated case.
So I guess one more clarification. A public complaint that is a duplicate, meaning that a single person filed 2 complaints or 2 different persons filed the same complaint?
It's typically the same person filed the same complaint multiple times.
And I heard the numbers, but if I can, how many public complaints were received? I thought I heard you say,
So the sampling that we did
Yeah.
was based off of 1,450 closed public complaints. And to generate the data with a 5% margin of error, we looked at 304 complaints, public complaint cases. It was a manual process, and so that's why we had to consolidate down to a smaller population of cases to try to generate statistically reliable data. But the cases, I think right now we have over 1,500 closed public complaints and over 3,200 public complaints that have been received in total since January of 2023.
Yeah, and to expand upon that, of the 3,200 public complaints, and this is page 3 of the statistical profile, that represents about 2,100 unique officers, because sometimes you'll have an officer that's involved in multiple complaints. So just to kind of give you that data, there's 3,200 complaints, about 2,700 individual complainants filed those 3,200 complaints, and that reflects about 2,100 unique officers. Yes,
Anne Marie,
Board Member Clark.
the document that you
Yeah.
repeatedly refer to, is that the document we received in
Yeah.
February?
Yeah, oh, this is the one you received with your April board
okay.
member packet. It's online. You guys can click on it in the app. And it's one that's similar to what you've received at each of the board meetings where we go over the statistical profile in great detail. But again, since you kind of now know what each of those pages represent, we wanted to specifically answer questions about the public complaints because that's where most of your questions were generated in the past.
I do have another question. With the public complaints, what's the timeline again on that?
You mean for how long it's taken us to respond or get information from the agency?
No, we'll say a community member files a complaint.
Yeah.
And are they responded to once they file the complaint, or how long does that timeline take?
Sarah
So
knows that. Thank you.
our intake and disposition bureau, as soon as a public complaint is received, we respond within 1 business day. And then we also notify the agency within a business day, unless it's a complaint regarding a chief or sheriff. And then we consult with our professional conduct bureau chiefs to determine whether or not they want it referred to the agency or if they want to look at it first themselves. But typically everything is within 1 business day. Then we wait for the agency to respond, and we're following up every 30 days with the agency to make sure that we're getting the information.
I guess my last question then, I noticed when we do have public comments, some of the family members are saying that they filed a complaint with Post, but they haven't heard anything. Could we clarify what's going on with that?
I have my staff working with those individual public commenters today to identify what perhaps the issue is, but we do keep record of all of our email correspondence and all of our telephone calls and track the response rates of everything.
That's why it will help for us to look into it. It's hard for us to respond, as you can imagine here today. I don't have the data in front of me, but we have a team of folks in here that handles intake, which is what Sarah's bureau oversees. And so they can follow up with those individuals and find out where we may have missed the communication. Yeah. Thank you. Oh, yeah,
Statement.
sorry. Yeah.
Will that information be provided to the board?
Certainly, if you would like us to follow up. The one thing we can't do in a public hearing, as you can imagine, is get into detail about the investigation itself. Obviously, that would compromise the integrity of the ongoing investigation for us to reveal specifics, but we can tell you whether we followed up and what that follow-up was. You're welcome. Thank you.
Any other questions? No.
Thank you, Sarah.
We now move to the next items on the agenda. We have 5 cases to hear today. We will only be reviewing the facts and evidence as presented by this division. This is not an evidentiary hearing. The rules of evidence do not apply here. Evidence is not formally admitted into the record. There's no need to make any objections, and objections will not be ruled upon. Under the Penal Code and the applicable state regulations, this initial hearing will result in a recommendation to the Commission with respect to these matters. Subject to the Commission's determination, the matter may then be set for full evidentiary hearing before an administrative law judge to determine whether the allegations are true and justify discipline. For those commenting on each item, at this early stage, the board must only consider the facts that the division, after investigation, believes can be proven at a later date at an evidentiary hearing. For that reason, today, the board will entertain arguments as to whether or not these facts, as presented by the division, demonstrate clear and convincing evidence. In other words, a high probability that the serious misconduct, as defined in the Penal Code Section 13510.8 and the Commission Regulation 1205 occurred. Actions by the board or the commission prior to a full evidentiary hearing do not constitute final determination that an officer did in fact engage in misconduct or that the revocation or suspension is ordered. That will be determined after the evidentiary hearing. At the conclusion of each law enforcement consultant's presentation, the board will have the opportunity to ask questions and then public comment from the subject officer and or their counsel will be taken, followed by members of the public. Further discussion by the board will be allowed if necessary. The board will go into closed session deliberations after each case or until all cases have been presented and adjourn in a closed session to deliberate on all cases presented after reconvening into regular sessions. Votes will be taken on each case. Post case 2311370, Jose Zavala, and number 2, post 2311373, Julio Quintinilla, employing agencies, Los Angeles Police Department. At this time, I call upon law enforcement consultant David Cyber and Carrie Woodley, an attorney with Legal Affairs Bureau, to provide the report in these matters involving the 2 officers that I've mentioned, and who at the time of the events of the issue of this case were and still are employed by Los Angeles Police Department. Law enforcement consultant Dave Cyber will present information regarding the service record and allegations or serious misconduct for each officer, followed by a presentation regarding the factual circumstances of the December 18th, 2021 incident. Following the presentation, each officer and their counsel will have time to provide public comment to the board regarding the facts and circumstances. Mr. Cyber and Ms. Willie, you may proceed.
Good morning, Chairman and members of the board. Excuse me. My name is Dave Sieber, and I'm one of the law enforcement consultants assigned to the Professional Conduct Southern Bureau and the Peace Officer Standards Accountability Division. With me today is Carrie Woolley, an attorney with our Legal Affairs Bureau. I'm here today to present post-case 2311370 involving Los Angeles Police Department Officer Jose Zavala and post-case number 2311373 involving Los Angeles Police Department Officer Julio Quintinilla. These cases are associated with a single officer-involved shooting incident involving allegations of serious misconduct arising from Officer Zavala's and Officer Quintinilla's use of force, which resulted in the death of an adult male, whom I will refer to as the victim throughout this presentation. It is the division's determination that clear and convincing evidence exists to demonstrate that Officer Zavala and Officer Quintinilla committed an act of serious misconduct as set forth in California Penal Code Section 13510.8 on December 18th, 2021. Specifically, the division has determined that Officer Zavala and Officer Quintinilla committed the following acts of misconduct. California Penal Code 13510.8 B3, physical abuse, including but not limited to the excessive or unreasonable use of force. In this presentation, I'll present a brief outline of the division's findings regarding this matter. First, I would like to discuss Officer Zavala's background. Officer Zavala began his career at the Los Angeles Police Department on May 26, 2009. On October 9, 2009, Officer Zavala was promoted to the position of police officer. This position is a peace officer as defined under Penal Code Section 830.1A. Officer Zavala earned a post-basic certificate on January 10, 2011. Next, I will provide a summary of Officer Zavala's prior discipline. As stated in the initial statement of findings on pages 6 through 9, Officer Zavala is the subject of 8 allegations of serious misconduct submitted to the division. These 8 allegations include this case and its related civil matter, 2 allegations that Officer Zavala demonstrated bias, which the division closed with no further action as it lacked jurisdiction to review because the events occurred before January 1, 2022, and LAPD concluded its investigation before that date. 1 allegation of abuse of power and physical abuse from an incident on April 2, 2021, post case number 2502030, as well as a duplicate allegation of the same incident. Despite the fact that post case 2502030 was closed with a finding of no further action, LAPD sustained a single allegation against Officer Zavala for his excessive and unreasonable use of a front kick while dispersing a crowd on April 2, 2021. Ultimately, LAPD's personal complaint investigation resulted in a 5-day suspension with loss of pay and benefits. Lastly, there were 2 cases from 2024, which involve allegations that Officer Zavala engaged in an abuse of power and demonstrated bias, were both closed with no further action. The division would like to note that these cases were identified as unassigned in the ISF dated February 12, 2026, but have since been adjudicated. In addition, a review of Officer Zavala's Los Angeles Police Department personnel file indicated that on February 15, 2015, he was involved in a non-categorical use of force when he and his partner responded to a radio call of a prowl suspect. Upon arrival, the officers encountered the complainant, who was subsequently arrested for the warrant. During the complainant's booking process, he punched Officer Zavala in the jaw without warning. In response, Officer Zavala initiated a non-categorical use of force, striking the complainant 8 times with his fists. The complainant received facial bruising and a laceration above his eye and was transported to the hospital for medical treatment. After treatment, officers walked the complainant to their patrol vehicle, at which point he attempted to flee, resulting in a second non-categorical use of force. As a result of the collective circumstances and a complaint by a civilian witness, LAPD initiated a personal complaint investigation on Officer Zavala. The investigation resulted in 5 allegations of misconduct, 2 of which were sustained for Officer Zavala's unauthorized use of force and for his use of tactics that substantially deviated from the department's tactical training. LAPD's personal complaint investigation found that Officer Zavala's use of force was necessary and that his first 2 punches were within policy. However, the investigation found that he let his emotions lead to excessive force when he followed up with punches 3 through 8. Ultimately, Officer Zavala received a 15-day suspension with loss of pay and benefits. This incident occurred before January 1, 2022, and therefore was not actionable by post. Now I would like to discuss Officer Quintinilla's background. Officer Quintinilla began his career with the LAPD on February 22, 2016. On August 7, 2016, Officer Quintinilla was promoted to the position of police officer. This position is a peace officer as defined under Penal Code Section 83.1A. Officer Quintinilla earned a post-basic certificate on September 27, 2017, and a post-intermediate certificate on September 23, 2020. Lastly, I will provide a summary of Officer Quintinilla's prior discipline. As summarized in pages 6 through 13 of Officer Quintinilla's initial statement of finding, the division has received 20 allegations of serious misconduct involving Officer Quintinilla. These allegations involve this case, its related case, and a duplicate allocation, 2 allegations involving abuse of power and a demonstration of bias, which the division closed as it lacked jurisdiction due to the events occurring prior to January 1, 2022, and LAPD concluded its investigation prior to that date. 1 allegation that Officer Quintinilla demonstrated bias and used excessive force from 2023, LAPD found the complaint was demonstrably false. 4 allegations that Officer Quintinilla engaged in abuse of power from 2023, in which LAPD found that the complaints were unfounded in 3 of the cases, and Officer Quintinilla was exonerated in the 4th case. 2 allegations that Officer Quintinilla engaged in physical abuse, excessive use of force, in 2023 and 2024. LAPD determined that the complaints were unfounded in part, and that the officer's actions were exonerated and the complaint was demonstrably false. Lastly, there were 8 allegations that Officer Quintinilla demonstrated bias, 6 of which were from 2023, 1 from 2024, and 1 from 2025. LAPD determined that 6 of the complaints were demonstrably false, and the remaining 2 were unfounded. The division closed these cases following the determination that there was insufficient evidence that serious misconduct had occurred. In summary, The division closed these 17 allegations of misconduct after finding that there was insufficient evidence that Officer Quintinilla engaged in serious misconduct. A review of Officer Quintinilla's LAPD personnel file indicates that he was involved in 13 non-categorical uses of force, all of which were adjudicated as in policy. Additionally, Officer Quintinilla was involved in 7 vehicle pursuits. 6 of the pursuits were adjudicated as in policy, and one which occurred on July 6, 2021, resulted in a sustained finding and a penalty of admonishment. Now I will provide a factual basis for the captain use of force incident involving Officers Zavala and Quintinilla. On December 18, 2021, at approximately 16:54 hours, Communication Division received a call that the victim had walked out of his residence holding a kitchen knife and was threatening members of the community. The victim is described as an adult male standing 4 foot 9 inches tall and weighing approximately 98 pounds. According to a relative of the victim had been drinking alcohol and using narcotics since he was 18 years old, causing what the relative described as an altered state of mind. At approximately 17:01:31 hours, a sergeant from Los Angeles PD's Newton Gang Enforcement Detail, hereinafter referred to as the incident commander, was first to respond to the call. The incident commander arrived on scene, exited his patrol vehicle, and attempted to communicate with the victim, who was sitting idle on the steps in front of an apartment building located near the victim's residence, holding the knife in his right hand with the blade pressed against his neck. Can advance the slide, please? This is a image of the location. The steps there is where the victim was sitting, just for your reference. At 17:02:05 hours, Officer Zavala and his partner, Officer Quintinilla, from LAPD's Newton Gang Enforcement Detail, followed by 2 additional officers from LAPD's Newton Patrol Division, responded to the attempt suicide call for service and contained the victim. Officers Zavala and Quintinilla established a perimeter position to the west of the victim and were designated by the incident commander as lethal cover officers. At 17:03:02 hours, the victim placed the knife blade against the side of his throat, prompting multiple officers to yell, "Don't do it." The incident commander directed one of the Newton Patrol Division officers, hereinafter referred to as Officer 1, to deploy his 40mm less lethal launcher. However, he withdrew the command before Officer 1 could execute the order. Another officer from LAPD's Rampart Patrol Division arrived on scene in his patrol vehicle. The incident commander directed this officer to join the arrest team. At 17:03:35 hours, the incident commander retrieved a ballistic shield from his patrol vehicle and gave it to another officer. The incident commander yelled to Officers Zavala and Quintinilla, "You still got lethal coverage right there, right here." For the next several minutes, Officer Zavala and Officer Quintinilla, along with the incident commander, alternated communicating with the victim. Advance the slide, please. Moments later, the victim stood, held the knife to his throat, and gestured the sign of the crucifix across his chest with his left hand. The incident commander directed Officer 1 to deploy his 40mm less lethal launcher by announcing, "40, stand by." At 17:04:06 hours, Officer 1 discharged one 40mm round at the victim from a distance of approximately 30 feet. The round struck the victim in the abdomen but did not appear to have any effect. The victim walked down a short flight of steps towards the officers and then sat idle on the bottom step while continuing to hold the knife against his throat. At 17:05:36 hours, body-worn video recordings captured officers alerting one another that a bystander was attempting to exit the apartment building behind the victim. The incident commander yelled, "Hey, stay right there. Do not come out." Additional officers warned the bystander to stay inside and to move away from the windows. The bystander complied with the officer's orders and remained inside the building with the door closed. The victim appeared to be oblivious to the presence of the bystander who was inside the apartment building behind him. 2 additional Newton Gang Enforcement Detail officers arrived on scene. One of the officers deployed a shotgun, positioning himself as a lethal cover officer alongside Officer 1. The other officer deployed a less lethal beanbag shotgun and was directed by the incident commander to move to the west side of the containment perimeter to provide less lethal cover for Officer Zavala. The incident commander and Officer Zavala continued alternating commands to the victim. The incident commander utilized the patrol vehicle's PA system to communicate his commands. At 17:10, 17 hours, the victim stood up, removed his hat, and held the knife above his shoulders while looking east towards members of his family who were standing behind the containment perimeter. The incident commander announced, "Get ready," while he transitioned from the passenger side of the patrol vehicle to the driver's side, where Officer 1 had taken cover. The incident commander announced 40-40 up. After standing, the victim took 4 slow steps forward, turned to his left, west, and yielded to the officer's commands to stop. Contemporaneously, Officer 1 announced 40 stand by. As the incident commander instructed him to fire the less lethal launcher, Officer 1 fired one 40mm round from a distance of approximately 22 feet, impacting the lower right side of the victim's torso. Approximately 0.382 seconds after the 40mm less lethal projectile was fired, Officer Zavala discharged the first of 3 rounds from his service pistol from a distance of approximately 25 feet and behind the driver's side door of his police vehicle, striking the victim. Approximately 0.322 seconds after Officer Zavala discharged his 3rd round, Officer Quintinilla fired a single round from his service pistol from a distance of approximately 28 feet and behind the passenger side door of his police vehicle. The victim fell to the ground and was subsequently detained. The victim received medical aid and was transported to the hospital, where he ultimately succumbed to his injuries. This slide gives a depiction of the location of the subject respondents, where the red line is drawn, just for your reference. On December 21, 2021, the Los Angeles County Coroner's Office performed a post-mortem examination of the victim. The report indicated that the victim sustained 3 gunshot wounds, 2 to the torso and 1 to the neck. Ultimately, the report concluded that the victim's death was a result of a gunshot wound to the torso. The Los Angeles Police Department's Force Investigation Division investigated the officer-involved shooting, and the results were conveyed to LAPD's Use of Force Review Board. The Use of Force Review Board was critical of Officer Zavala's and Officer Quintinilla's perception of an immediate threat, and they found that their actions were not objectively reasonable, proportional, or necessary. A subsequent department-initiated personal complaint investigation reached a sustained finding of out-of-policy administrative disapproval regarding Officer Zavala's and Officer Quintinilla's use of force. Neither Officer Zavala nor Officer Quintinilla were referred to an LAPD Board of Rights. Ultimately, Officer Zavala received a 10-day suspension with loss of pay and benefits, and Officer Quintinilla received a 5-day suspension with a loss of pay and benefits. Later, on February 3, 2023, the victim's family filed a civil complaint, which initiated a second LAPD personnel complaint investigation, alleging Officer Zavala's and Officer Quintinilla's excessive use of force. This investigation ultimately determined that the allegation was unfounded for both officers. However, on March 18, 2025, the Los Angeles City Council voted to authorize the city attorney to expend up to $8 million to settle the victim family's wrongful death lawsuit, which was filed in the U.S. District Court for the Central District of California. As of today, the Los Angeles County District Attorney's Office Justice System Integrity Division has not reached a charging decision and continues to review the incident with the assistance of an independent police oversight firm. The facts I've just recited support the division's finding that Officer Zavala and Officer Quintinilla were involved in serious misconduct, specifically physical abuse, including, but not limited to, the excessive or unreasonable use of force. For purposes of the division's analysis, clear and convincing evidence means evidence of a charge is clear and convincing so long as there is high probability that the charge is true. The evidence not need establish a fact beyond a reasonable doubt. The division recommends that Officer Zavala's post-basic certificate and Officer Quintinilla's post-basic and intermediate certificates be revoked or suspended based on the following. After a review of the evidence developed in LAPD's Force Investigation Division investigation and personal complaint investigations, multiple body-worn video perspectives of the incident, and an analysis of California Penal Code Section 835A and the 2025 U.S. Supreme Court decision in Barnes versus Felix, the division concludes that Officer Zavala and Officer Quintinilla engaged in serious misconduct as defined in California Penal Code Section 13510.8, B3, and Commission Regulation 1205A3, physical abuse but not limited to the excessive or unreasonable use of force. The division's assessment is supported by the following findings. The victim was contained and remained no closer than approximately 22 feet from any officer. Once contained, the victim posed a danger only to himself. The victim's demeanor was not particularly threatening. The victim did not pose an imminent threat to the officers who were positioned behind police vehicles, nor to members of the public who were located outside the containment perimeter. The victim was slow to respond to verbal commands and less lethal force, suggesting the possible presence of a mental or physical health condition, cognitive impairment, or the influence of a controlled substance. Lastly, at the time deadly force was utilized, the victim had complied with officers' commands to stop. Officer Zavala and Officer Quintinilla effectively used distance and cover to create time and space in conjunction with de-escalation measures. However, they initiated deadly force before exhausting available less lethal options. The division determined that Officer Zavala and Officer Quintinilla failed to meet the requirements set forth under California Penal Code Section 835A C2, which limits the use of deadly force to circumstances in which it is necessary to defend against an imminent threat of death or serious physical injury. Additionally, the division requested an independent subject matter expert opinion from Robert Handy of Tri-Chief Consulting Services. The subject matter expert concluded that Officer Zavala's and Officer Quintinilla's use of deadly force was inconsistent with the tactics being directed by the incident commander and was not based on an objectively reasonable belief that the victim posed an imminent threat of death or serious bodily injury to officer or others. Rather, the force was precipitated by the danger the victim posed to himself, which does not satisfy the statutory threshold for deadly force. Based on its investigation and after considering the factors enumerated in Title 11, California Code of Regulations 1213A, the Peace Officer Standards and Accountability Division determined that Officer Zavala and Officer Quintinilla failed to meet requirements set forth under California Penal Code Section 835A C2. Officer Zavala's and Officer Quintinilla's conduct demonstrated a disregard for public safety, and their conduct was inconsistent with the duties and responsibilities of a peace officer. Accordingly, the division finds that Officer Zavala's and Officer Quintinilla's actions constitute serious misconduct, warranting the revocation or suspension of their post certifications. I would now like to present the board with three perspectives captured by the body-worn video devices of Officer Zavala, Officer Quintinilla, and Officer 1, followed by a corresponding timeline of the aforementioned events. These videos are about 1 minute each, and we can replay them. There's a bit of deconfliction or their de-escalation measures for the first 30 to 40 seconds, and then it goes into the deadly force. We'll start with Officer Zavala's.
Mr. Seaver, before you start with the video, just a disclaimer for the public and the sensitive material. This may be disturbing for some. Just wanted to preface it by saying some of you may not want to watch the video. However, we are going to play it, so I wanted to provide that disclaimer. Thank you.
Okay? Mira, mírame a mí, okay? Mira, pon el cuchillo al lado. Mírame a mí, señor. Mira, señor. Señor. Hey, sorry, let me keep going. Hey, sorry. Let me keep going. He's dropping.
Drop it on the ground. That's it. That's all I need you to do. Okay? Please drop it on the ground, okay? Just put it down, dude. That's all you gotta do. Just drop it down. Drop it down on the ground. Just put it on the ground, alright?
Stop right there. Stop, 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 stop. Stop. Shots fired off the top. Shots fired off the top. Put it up, put it up.
The shots were so contemporaneous that you almost couldn't tell. The 40 millimeter less lethal hit him in the hip. Less than a third of a second later, Officer Zavala initiated the first of 3 rounds, and less than a third of a second after his third round, Officer Quintinilla initiated his single shot. Some of the other perspectives are a little clearer.
Drop it on the ground. That's it. That's all you need to do. Please drop it on the ground, okay? Just put it down, dude. That's all you gotta do. Just drop it down. Drop it down on the ground. Just put it on the ground, alright?
Don't walk over here. Don't. Shots fired. Shots fired. Officer is out. Turn it up. Turn it up.
Last perspective is from the other side to the east. That's to the left of Officer Zavala and Quintinilla. And you're going to see through the door frame from Officer 1, who was using the less lethal device. You can see him take his shot, and then you can kind of time when Officer Zavala takes his first shot because you can see him through the window.
Units respond to 27 and goes into block outbound traffic, 409 and display by traffic, code 3. 100%, bro. Drop it on the ground. That's it. That's all you need to do. Units from outside unit as well. Please drop it on the ground, okay? Just put it down, dude. That's all you gotta do. Just drop it down. Drop it down on the ground. Just put it on the ground, alright?
Hey, 47! Drop it. 40 up.
Shots fired. Shots fired? Yeah. We got shots fired. Shots fired. Yeah.
All right, hold it down.
Just put an administrative timeline up here because I know I pushed out a lot of dates and times. I think these are the pertinent ones that talk about when the actions took place from the department. There are 2 slides here I'll leave up for you. And with that, I'm happy to answer any questions that the board may have. Thank you.
Board have questions? Commissioner
do.
Johnson?
Yes, Johnson. When you was speaking on Zavala and Quintinilla about the prior complaints that was filed, maybe next time a PowerPoint of all the complaints and then the separation of those that was unfounded and those that were sustained. Because you said a lot with especially Quintinilla. He had 20 complaints filed. And it sounded like most of them was unfounded. And so I was kind of lost in the numbers. So for next time, maybe clarity, we can actually see it. And I think that would help me better.
Thank you, Board Member Johnson. And it's a very valid point. And I did take the time to put together a more sort of streamlined summary of those, if you'd like me to read them again. I know that I wanted to provide enough information so that you understood what the cases were, but now I've distilled it down to just the sort of the decision. Would that be helpful?
But no, you don't have to reread them, but I'm just saying next time.
Yeah, understood.
I get the whole gist. I did read it, but with more clarity.
Understood.
Crawford?
Crawford. I read the report thoroughly. I had to, at one point, sit back and go back and read it. I noted that the coroners ruled this as a homicide per report, correct? And that Chief Moore at one point submitted a report stating that he felt the officers were not within post guideline as well. But yet we have where an internal group, I forgot the name, I'm sorry, is still looking into this matter. So, as I said, I went back, looked at it, read it. One of the things that I wanted to be clear on, you mentioned that there's a 22 feet radius. The officers were 25 and 28, correct?
Correct.
Within seconds, I sat there and counted it on my fingers after the beanbag was deployed, that within 3.282 seconds, the first 3 shots were fired and then the 4th one, correct?
That is correct. 0.3 seconds, so a third of a second After the 40 mm was fired, the first of 3 shots was fired.
Okay, and this was the part that I got kind of confused on. The sergeant and maybe a commander, sergeant was shouting out 40-40. That's in reference to the beanbag, right?
Correct.
In the report, did he at any time said, because I know that he assigned them as lethal officers, correct? So from my understanding for command purposes, does the officer have to say lethal in order for them to shoot, or he did not have to say lethal?
So the two questions. The first one, he did not. He did ready the 40 mm less lethal by saying 40-40 up, which is a readying command. In terms of whether or not he has to authorize or command for deadly force, no, he doesn't.
Okay, but it still needs to be within that 22 perimeter, correct?
Well, 22 feet I was simply noting so that the board and the commission could understand that at no point was the victim any closer than 22 feet.
Okay.
It was actually further than that to Officer Zavala and Quintinilla, but I believe he was about 22 feet from Officer 1 who
Okay.
deployed the 40 mm. So I went with the closest distance to any officer.
Okay, perfect. Thank you, sir.
You're welcome.
Baba, quick question. They are still currently employed and working today?
Yes.
And just to reiterate what I believe I heard you say, charges are still under review.
That is correct.
Thank you.
Any other questions? Ms. Finn?
The 2 officers received disciplinary action for this incident, correct?
They did.
And I think one received 5 days suspension, the other 10.
Correct.
What was the reason for the discrepancy?
So I would be speculating, but I believe based on Officer Zavala's prior incidents of use of force, he had 3 prior sustained allegations that resulted in suspensions of 15 and 5 days. He would have received more because they were looking at his service record, and he had more incidents of misconduct allegations, whereas Officer Quintinilla, despite having 20 allegations, none of those were sustained except the captioned matter that we're talking to. So he had not been disciplined for any other misconduct allegations in the past.
I just want to add to that, if you look at the dates for Officer Quintinilla's complaints, those are all subsequent to this incident as well. So that would have gone to that as well. His service record, the complaints come in after this incident.
Okay, thank you.
Go ahead.
Just a quick question. I don't know if it was outlined in the report. I'm unfamiliar with the Los Angeles Police Department term categorical use of force. Do you have a definition?
Do not.
They don't have one in there.
Thank you.
I did do some research on this, and it's sort of the term has to just do with the level of force applied. And in reading their policy, the use of force policy, it's not super clear. So a fist punch could be a categorical use of force, or it could not, depending on how it's applied. And
thank you. Liable?
Yes. The 3 cases upheld, do we know how close in proximity those 3 upheld cases were?
To be fair, we're speaking about Officer Zavala.
I think it was Quintinilla. Whichever one had the 3 cases upheld.
Yes.
I'm sorry.
So again, Officer Zavala had, let me just go through these. I think it would be helpful just to clarify. So the 2 use of force cases that we're talking about today, the criminal and the civil matter, those 2, there's 8 total. Then he had 2 bias allegations that we did not have jurisdiction for. He had 1 assault or abuse of power in 2024 that was unfounded. He had 1 bias allegation in 2024 that was unfounded. He had 1 use of force and abuse of power in 2021, to get to your question, which was sustained for a front kick in which for which he received 5 days of suspension. And then going all the way back to 2015, prior to post jurisdiction, his personnel records identified a sustained allegation where he threw 8 punches. 3 of the punches were considered within policy punches. The last 5 punches were considered out of policy, and he received 15 days for that. So in 2015, 15 days, 2021, 5 days, and then that brings us up to our current matter.
Thank you.
Ms. Crawford.
While we're not gonna consider the previous, just what's before us, but you do mention about the bias cases and how they were unfounded. I wasn't clear on how the determination of what could be considered bias and what is not considered bias. I did read it and I understood the grounds of the complaint, but it seemed that I think Officer Zavala has had more complaints about it, but they were unfounded, of course, correct?
Officer Quintinilla had bias allegations that were demonstrably false or unfounded. Again, I reviewed every single one of the 28 cases in question, reviewed the circumstances of those. I can't get down into the exact details of what happened in those cases, but I'm going by what the agency's determination and then subsequent evaluation of their investigation resulted in.
It just didn't seem like there was a clear defining measurement of what's consistent of what is biases and other than what we read. And that is concerning for me.
Thank you. Thank you, board member. There were several that were demonstrably false, and just to clarify, demonstrably false is stronger than unfounded, and in some cases they can even imply that the complaint may have been intentionally fabricated. So that doesn't mean that we don't review them, but it's just to be aware of that. An unfounded allegation is false or did not occur, or there's no factual basis for the complaint. Simply not enough evidence.
Thank you, sir.
You're welcome.
I have a question. Do you know after the board deemed the shooting out of policy, who mets out the discipline?
So in this case, you want to answer that?
I can answer it or you can answer it.
Go ahead.
So generally that would be either the agency or with LAPD, I think it's usually the Board of Rights, although Ms. Wilcox will be better able to answer that since she's familiar with their particular procedures.
And I assume the unit that did the citizen complaint investigation was different than the shooting board.
It appears to be, yes, because they reached a different
Yeah,
conclusion.
and their conclusion was unfounded,
Yes,
which basically means the complaint was false.
yes.
Thank you. Board have any other questions? Ms. Pena?
Yeah, was there, I read one, well, I guess I didn't. Was there ever an explanation given for why the mental health unit wasn't called?
There was not an explanation as to why the mental health unit was called. That was mentioned briefly in the report that was a possibility, but there was not an explanation as to why it wasn't called. Obviously, as we all know, Los Angeles is a really large city. It's not clear whether they just weren't available, whether there was a call out and they weren't able to respond or not, but they didn't respond to this scene.
And I could also add that from the first time the call went out to when the OIS, the officer involved shooting occurred, was 16 minutes roughly. But officers were on scene for around 13, 14 minutes. So I just don't know that they had the time to make the call yet.
But they called for an ambulance, correct?
They did.
They did.
Almost immediately when they got there, right?
That's correct.
Correct.
Yeah, Johnson. So we know that there has been no criminal charges filed, according to this shooting. the decision we make today will have no effect on the criminal trial, correct?
That's correct.
Okay. And I guess what I'm getting at is that the district attorney or the county involved in this particular shooting has not determined on whether the officers were involved in an unjustifiable shooting at this time, correct?
That's correct. They are still making a decision whether or not any criminal charges would be brought. There's an array of different penal code provisions that they could look at. They could look at Penal Code Section 149, which would be basically an unjustified use of force by a public official. They could be looking at voluntary manslaughter. They could be looking at murder, although that would be highly unusual in a situation like this. But there's an array of different penal code provisions.
Crawford, so not to be political, at the time this was the DA was Gascon, correct? And we now have a new DA. So, okay, I just wanted to kind of get a perception of the culture at the time of when the shooting and the crossovers of administration. Okay, thank you.
Any more questions by the board? Okay, with that, we're going to take a 10-minute break before the next item.
Before we have 10-minute break before we have officers counsel and the officers provide comment to the case. So we won't be moving on to the next case, but we will be hearing from officers counsel and officers. Thank you. Yeah, I know.
We're missing one, oh, no, she's there. She's there. Okay, we're going to go back on the record now, so please take your seat. At this time, oh, I'm sorry. No, sorry. I understand both officers are represented and you will each be given 5 minutes to speak and the time limits will be strictly enforced. So please ensure that you complete your comments before the allotted time. While commenting, keep in mind the board will only consider the facts as presented by the division today and will not consider any additional facts or defenses at this time. The sole question before the board today is the following. If the facts offered by the division today are proven at a later hearing, do those facts demonstrate clear and convincing evidence, a high probability that serious misconduct as defined in Penal Code Section 13510.8 and Commission Regulation 1205 occurred? Leslie Wilcox is attending for both officers. Please, welcome.
Good morning. My name is Leslie Wilcox. I'm a panel attorney with the Los Angeles Police Protective League, and I'm representing both Officer Zavala and Officer Quintinilla related to this post-investigation. My basic statement that I would like you all to be aware of is the U.S. Supreme Court case Graham versus Connor, which is referenced in the materials, but it specifically provides for any use of force by any law enforcement officer in the country, but we're specifically talking about California, that use of force is viewed through the perspective of a reasonable, similarly trained officer under the same circumstances, based on the totality of the circumstances. I believe in this particular case, the officer's actions do not rise to a clear and convincing level. LAPD's standard that they use is preponderance of the evidence, which is lower than posts. Both officers expressed their fear of the imminent threat that they believed this victim posed to them based on the knife and his prior actions. So that is the reason that I believe that the post will not be able to prove it beyond clear and convincing. I would also note that the division is recommending either revocation or suspension. And so if this board disagrees with my vision of the law as it applies to this particular case, then I would ask that you recommend suspension as opposed to revocation. I heard a lot of your questions that you asked the law enforcement consultant and Ms. Woolley, and I do have information on those generally if you would like to ask. But my position for the public comment for this particularly is that based under Graham versus Connor, that their fear of the imminent threat was reasonable based on their training and experience in the circumstances that they were presented with. Thank you.
Board questions?
Crawford.
Ms. Crawford?
You mentioned Graham versus Connor.
Yes, ma'am.
And could you give a quick summary of that case because you mentioned it?
I can. It's very old, and it's interesting that it is now applied to all uses of force by officers. It was a situation in which a man was seen acting erratically and not following officers' commands, and he ends up getting into his car and not listening to what they are saying. They use force to remove him from the car, and a use of force does occur. It is later determined that he was having a diabetic episode, and these were the reasons that he could not comply and was acting in a way that appeared to be very strange. So the Supreme Court ended up saying that if a reasonable officer in that situation would have perceived this man's behavior to be the same way, then that use of force is reasonable. That is a very slim version of that case.
Okay. You also mentioned that the position is that, and we keep saying the word reasonable, and perception of what is reasonable and what is not reasonable when you apply lethal force in this case. I guess where I'm going at is it's it's the mindset of the officer is concerning. The purpose of SB 2 was to kind of in a sense, to protect the community with of guarding officers being able to move from, let's say they got suspended or fired, and then we're able to move somewhere else to possibly repeat things, maybe not as so much as being lethal, but still repeat the same type of practice.
Yes.
And that's concerning in this. And so you mentioned that the officers said that they are concerned about, that was the last part I didn't catch.
Their imminent fear of the victim's behavior, is that what you're talking about?
No. I guess you were talking about them being remorseful or.
They are, but I did not say that.
Okay, I kind of.
This is a tragedy.
Right.
They did not anticipate that being what their day was going to look like that particular day at work.
Ms. Clyble?
Imminent fear
Yes, ma'am.
from behind the car, protected by a vehicle, a minimum of 22 feet away from a knife.
Yes.
Okay, thank you.
Officers are routinely trained at LAPD's academy and throughout their career that the distance of a knife is incredibly dangerous to them, that 22 feet is not very far. I can't remember what the timing is that they are trained on that, but it is a very short amount of time that someone can use a knife to throw at an officer or another pedestrian or civilian nearby. And 22 feet is not considered a very long distance for the purpose of an edged weapon.
I have one more question. So I keep hearing post-training and standards training, and then I hear LAPD has their different practices that they deem as acceptable and not acceptable. And this is where we're kind of getting a little bit confused on.
Yes.
At least.
I can see how that could sound confusing. My understanding is that POST, and correct me if I'm wrong, POST is a general basic certificate, and then they have advanced certificates, and you can move yourself further throughout both the POST system as well as your own agency. I believe LAPD's position, if I could speak on behalf of the entire department, which would be hard to do, is that they have more extensive training. They go a little bit further, and they do it more often and in more specific scenarios. So I believe they feel that they provide more and intense training than a POST certificate provides.
So does their training that you know of align with POST training?
Oh, absolutely.
So it aligns, and then they do additional training?
Yes, they follow POST to the letter, as far as I'm aware.
Okay.
Mr. Johnson?
Yes. I heard you speak about Brown versus Connor, which is basically a national law, to my understanding. However, in 2019, I was part of the coalition to get AB 392 passed, which is the use of force legislation. So California State has its own use of force legislation. They removed the word reasonable and changed it to necessary.
Yes.
So the question becomes for us is, was it necessary for the officers to fire as quickly as they did?
Yes, LAPD updated their policy to include that new code section regarding necessary, but it does still include the Graham versus Connor standard. So I would say it's similar to LAPD's training versus POST. California is slightly more strict than the rest of the country in their officers' use of force. The officer's statements to the Force Investigation Division the night of the officer-involved shooting, I believe, described what they believed was reasonable and necessary on their perception. And I believe you have the transcripts for that.
And so if I heard correctly, the officers believed that they were in danger or imminent danger from the victim?
Yes. They took into account the totality of the circumstances. There had been prior updates, which I believe was presented to you as well, that this person had also been chasing people in the street with a knife. And the initial less lethal round, as well as their attempts at de-escalation verbally, had been ineffective. And based on their training experience, someone advancing with a knife with other civilians around having not complied and the less lethal not being effective, both with the way that the victim turned his body as well as the location in which the officers were, the two of them, not everyone it seemed, but the two of them believed that he posed an imminent threat both to themselves, their partners, and the people around them.
I guess my last question then. In the video, it appeared that the shots were simultaneous from the non-lethal to the lethal. And I'm not clear where the imminent threat of danger was coming from with this young man that had a knife to his own throat. Not in a rage of charging, not in a rage of even giving the idea in the video that he was going to attack someone. So anyhow, I'll pin it there, but it's very concerning.
I understand. I think officers have a very difficult job to do, to make split-second decisions with the information that they have available to them and how they've been trained. And in edged weapon or knife calls, where the information that the officers had was that he had been chasing people. I believe when he's walking down the steps, the knife is not up to his throat. It appears that he did want to try and harm himself, but when he advanced towards the officers and did not stop as requested based on all the information that they had and the distance, which it appears that 22 feet sounds like a large distance, but my understanding for law enforcement training is that is not a large distance with a knife. And that was the reason that they felt that it was necessary.
I guess my last question then, truthfully.
Sound like a
is
lawyer.
that the timing between the non-lethal shooting and then the lethal shooting, it appears that there was no chance of even seeing if the non-lethal shooting did any damage.
Yes, I can see how you could see it that way. The 40mm round was fired right before the first lethal round was fired. And those officers are positioned in different places on the street. And I believe the two officers who used their firearms had a different perception of what the victim was doing.
Crawford?
So, and maybe this is the gander, and this is probably your thought or third person thought. Could you possibly explain why the coroner ruled it as a homicide?
I believe any of them are ruled as a homicide, and then the district attorney's office determines whether or not it's justifiable.
So if a person is killed by an officer, it's ruled as a homicide, and then the DA goes back on
And decides whether or not it was justified, because it's the killing of another human being.
Okay, I understand that.
The coroner doesn't make the decision if it was
If
okay.
it was a homicide or not, but based on his analysis and where he was shot, he based it on homicide. So I'm sorry, legal, can I ask legal counsel over here post to kind of, because that is.
Well, I mean, I just think that we don't know, right? So there's probably different standards applied to the determination of a homicide from a coroner's perspective. What's material to our decision is whether or not the investigation and findings that we've heard presented, if proved at a ALJ hearing, would be a basis for decertification. So I think whether the coroner, right, had a valid reason to determine homicide or not, may or may not matter, but I think we're going to be looking more at the investigation and findings as to whether we have a basis for decertification. And I think that's probably the clearest answer, because otherwise we're kind of speculating.
Not an attorney, so that's why I had to ask.
Mr. Clago, did you have a question?
No, I'll wait.
Okay. Ms. Wilcox, I assume, did you represent one or both in the internal investigations?
The force, The Force Investigation Division interviews the night of the officer-involved shooting. Yes, the LAPD just uses that information in their internal investigation. They don't re-interview them.
Do you know if that board mets out discipline or if that goes to another level?
If what does?
Well, the board said it was out of policy.
The use of force review board,
Right,
yes.
and one got 10 days, one got 5 days. Who decides that?
It goes, the use of force review board makes a recommendation to the chief, and then he makes a recommendation to the Board of Police Commissioners, the Civilian Oversight Committee, and then they direct the chief to create a complaint investigation, and then the chief is the one ultimately who decides the discipline.
I mean, obviously you have more experience with LAPD than I, but I have a hard time with the board saying the shooting was out of policy. And then another investigation said that the complaint was by the family was completely unfounded.
I think I can explain that. So I will try. Once the Board of Police Commissioners gets the chief's memo, which is the one you have, the chief of police wrote a memo to the Honorable Board of Police Commissioners. Once they get that memo, they make a determination of whether or not they think any complaint investigation, in this case, whether or not the use of force was within policy or out of policy. If they determine that it's out of policy, it gets sent back to LAPD and it automatically generates a complaint investigation. And that is what the chief used to determine the suspension days for these two officers. Anytime a member of the public makes a claim for damages against the city, which is what you have to do before a lawsuit is filed, that also generates an automatic complaint investigation. But they will take the words that were used. And so without having read that complaint investigation, but hearing that it was labeled as excessive force, the department determined that it did not meet the level of excessive force and they found it unfounded, probably also because they had already done a complaint investigation about the use of force being out of policy, if that makes sense.
Yes and no,
I
but
know,
thank you.
believe me, I'm
Okay.
familiar with the confusion at LAPD.
Ms. Pena.
Do you happen to know why, or has there ever been an explanation given that you know of as to why they did not call for the mental health unit?
I think it was not given in this particular case, but based on the other instances that I've been involved with at LAPD, in 2021, the MEU, Mental Evaluation Unit is what they have, was not used in that format. They are called to cases, but they will typically wait until the situation is calmed down before they will go and approach the suspect or the victim in this case. So at that time, even if they had called MEU, they would have waited until the victim was in custody before they approached to do an evaluation about what needed to be done. Their frontline's the wrong word, but they would, they sort of stand behind the officers and wait for the officers to make the situation safe. And then they would come and address the situation. In the years since then, that has changed slightly, but not a lot.
Thank you.
It's not a perfect system.
At this time, is the
Oh,
board.
Johnson, I'm sorry. Yeah, one more question, and it's for council. California law, AB 392, talk about necessary standard, changing the reasonable standard. We are to follow the California law, correct?
Yes, I mean, I think we can look at both bodies of law to make an analysis on these kinds of cases, but California law is going to be the one that probably is the most guiding, and that's going to be following 13.510. So, yes.
Thank you.
And Mr. Beatty, if I could, the division's position as to what the legal standard here is laid out in the ISFs under the analysis section. So we do cite the recent Supreme Court case out of 2025, Barnes versus Felix, which is a unanimous opinion of the Supreme Court. It does address that you do need to have objective, reasonable conduct, but you also need to assess the totality of the circumstances in this case. One of the things that was happening in the courts was that they were starting to drift into a moment of threat rule. And they were looking at what was happening right before the time that the officers took action or used force. And they reiterated that what the officers should be looking at, or when you're assessing the use of force, you need to look at all of the relevant circumstances, including facts and events leading up to the climatic moment, and determining whether the peace officer acted reasonably in using force. We also go over California law in this instance, including the language that you're speaking of, Board Member Johnson, which is Penal Code Section 835, including when you're looking at somebody, when you're using deadly force, which would be the necessary. That is in the ISFs for both officers.
Is there anyone from the public who would like to address the board at this time? When it is your turn, you may state your name and organization if you wish. You will each be given 3 minutes to speak, and the time limits will be strictly enforced. So please ensure that you complete your comments within the allotted time. Is there anyone who would like to, in the public, who would like to address the board? Welcome.
My name is Addie Kitchen, the grandmother of Stephen Taylor, who was murdered in a mental health crisis. And again, my question is, no one called to realize that this man was in a mental health crisis before they took the action to murder this human being? It's just unbelievable to sit here and to listen to why and how this young man was murdered. He wasn't a threat to anyone except himself. And for the officers to take it upon themselves to decide that he was a danger to anyone except himself. So why wasn't should have been someone to call to help this young man. This is exactly what happened to my grandson. No one called for help for him. They called the police. And we know when police show up, most of the time, the person that is in stress is the one that gets murdered. And it's just so unbelievable to sit here and to listen to what is going on in our country. I'm just, it's a lot. It's a lot to digest, to see people trying to decide whether these officers need to be decertified. As far as I can see and what I hear, they do not need to be on the street to protect and to serve human beings. That's their job. That's what we pay them for, to protect and to serve. And that has not happened. Thank you very much.
Thank you. Is there anyone else in the audience who would like to address the board?
Good morning. Beatrice Johnson. I just wanted to say that my concern as well is that there was no concern about this young man humanity, because he was in a crisis. He was in a mental crisis. And I'm sure that everybody on the scene was aware of that, because you're in a mental crisis if you're putting a knife up to your neck. And the fact that once, I think it's called the 440, once that command was given, and then just shortly after there were gunfire of shots to a human being who was in a mental crisis. So I feel like these officers, this is not their job. This is not for them. And I think they should be decertified so they would not work anywhere else, especially in the state of California. Thank you.
Thank you.
My name is Wanda Johnson. I'm the mother of Oscar Grant that was killed 2009 at the Fruitvale BART station in Oakland, California. I am really disturbed. I'm also an employee for NAMI, which is the National Alliance of Mental Illness. And it disturbs me that this young man did not get the proper help that he needed, but instead that the officers are taking the situation into their own hand and using deadly force when it's definitely not necessary. Sort of simply the same thing that happened to my son when he was killed, even though he did not have a mental challenge. The officers refused to de-escalate the situation, where these officers who killed this young man could have de-escalate the situation, but instead turned it into a deadly situation. And there has to be something done so that people who are suffering mental crisis or not suffering mental crisis are not killed, and the excuse used that the officers feared for their life. These officers, again, he said, were about 25 feet away from this young man, so it was no need for them to shoot and kill the young man. And as they tried or said they applied unlethal force, they should have waited, but yet they fired the firearm right after the non-lethal force was used. So again, we have to start somewhere, and it needs to really start right here, where these officers who cost this young man his life be held accountable for their actions. And we can't just let this go by without not seeing and doing something about it. The problem we allowed to occur is we allowed so many officers to get away with their actions, where other officers feel that they're not going to be held accountable when they follow suit and do an act such as killing someone when it is unnecessary. Thank you.
Thank you.
Hello, my name is Arlita Nance. I'm the mother of Thomas and Tamon Wilson. Tamon was killed August 18, 2023, and Thomas was shot and assaulted both from the back. POST is training for these officers to get hired. It's a part of their training. So we all got eyes and can see that that was not right, what they did to that man. No one was in danger of him doing anything. All he did was stand up on the stairs. We all have eyes we can see, but we still have to go through all of this stuff like, oh, what they didn't do right is policy and procedure. This is so unfair to families to continue to live in the trauma. Like, you can never say justice. It's no justice. And the one thing that I know, everybody sitting up here that's come to here to speak, that's even on the DOJ's list of current cases, they're all Black and brown people. Whatever training they're getting is not right. And something has to be done because they're really exterminating us legally and getting away with it and going on doing it other places to everybody else. And it's just unfair. They need to get other races doing this training. It's something else that needs to be done with the training of these people, of different race people or something, because it's just us coming up here saying what they did to us. Thank you.
Thank you.
Hello, I'm Catherine Wade. I'm Baldwin's mother from Antioch, California. The video was very disturbing. The victim was totally in a mental health crisis, and I don't know if that city or county have the mental health services, but they should have been brought in too. And then to see the distance from the officers, and then one officer shielded behind his truck, the victim was no way a threat to him. So just to kill an innocent, a sick person like that, it really hurts my heart. And and even to hear about the officers having other complaints, and it's a problem for me, and I'm very perturbed of the victims and the victims' families when things happen like this, that you go through all of this putting in complaints, the department's doing their investigation, the investigations take so long, and I'm just here watching this video the first time, and I can clearly see that these officers should have been not just suspended, but should have been fired. That was very disturbing to watch that victim that far away and the officers shielded, and they just released their weapons like that. And I'm pretty sure the training they have, they know that they were wrong. But a lot of times these officers have gotten away with doing a lot of things in the community, and it just become a norm to them. I don't know if they get off by killing people like that, but I know people too that were mentally ill patients and calls in my community, and sometimes the officers show up, and then some instances they'll kill them, not with guns all the time, just choke them and kill them. So a lot of things need to change when it comes to these officers handling these kind of calls. And that video was very disturbing. And for anyone to watch it, you already can see that the officers were wrong.
Thank you.
My name is Keon Bliss. I have been, I'm a former commissioner for Community Police Review Commission here in the Sacramento City. And to be honest, it's really hard to maintain decorum and be respectful when I see such callous disregard for the preservation of life that officers Zavala and Quintinilla displayed on video that we saw today. The idea that these officers had anything to fear from a man who was stumbling out of an apartment block with a knife from 22 to 25 feet away, and that they had a right and a justified reason to murder that man is patently absurd. It's outrageous. And honestly, like, it can't, like, it's just breathtaking in the incompetence of that, because there were like, they had them covered. We saw less lethal equipment deployed at the same time. Why would there be any sort of protocol where you can have less lethals deployed and pistols deployed? Why are they not calling it out? Hey, less lethals, put your guns away. There are too many families that are permanently scarred, traumatized from incidents like this, where officers just look at a person and just shoot first and ask questions later. Don't think about the consequences, because we all know in a society where only 1% of officers involved in shootings actually get prosecuted in the first place, that there will be any sort of accountability. Majority of officers know that. I've talked to enough and I've seen enough incidents to I recognize that. I don't believe for a minute that it's a matter of training, because officers know how to actually de-escalate situations involved. It really just depends upon whether they're white or not. There were recent incidents just from LAPD. In April of last year, Jillian Lauren fired shots at LAPD officers during a high-speed police chase, and she was able to be apprehended unharmed. Not only that, but was charged with assault and negligent discharge of a firearm and avoided jail time. There was also Anthony Whitsey, who last November shot at a police helicopter and refused to surrender, barricading himself in a home. Both of these people were white and they somehow survived, but these two officers couldn't bring this person alive. It's outrageous. They should not be allowed to wear the uniform, much less carry the power to kill somebody.
Thank you for your comments. Anybody else from the public like to speak? Welcome.
Good morning, everybody. My name is Lance Wilson, and I'm here. I support a lot of the families that have lost loved ones to police violence. But just to see the video was appalling to me. It was clear, as many other folks have seen, and I've said, that the officers were, 22 to 25 feet away, barricaded behind their cars. They used the less lethal weapons within less than a second. The lethal weapons were used. And I mean, it was clear that the man was in a mental health issue, but just hearing the other woman speak earlier that spoke before people gave public comment. I mean, the police are investigating the police. I mean, that's the problem right there. I mean, when we have these issues, when the police are out here committing harm to community members, I mean, they're being investigated by their own people. So, I mean, that's the problem right there. I mean, other folks had questions too, like, hey, I think it was, you, sir, you had a question about the process, about how it went up to the police commission and it comes back down and the chief makes a decision. I mean, that's the problem right there. But these officers should definitely be decertified. And yeah, I hope that happens today. Thank you.
Thank you. Seeing no other. At this time, does the board wish to adjourn to closed session for deliberation?
Yes, please.
Closed session for deliberation of both cases. The board members will now exit and each case will be looked at and decided individually.
understand why she was curious.
You have any good vacations planned? Case post 2311370, Jose Zavala, who at the time of events that issued the case and is still employed by Los Angeles Police Department. Are there any comments by the board?
Laura, I'd like to make a motion to decertify.
Okay. We have a motion to certify. Is there a second? Ms. Pena? Roll call.
Thank you, Mr. Vice Chair. Clavo,
Aye.
Clavo, I. Crawford,
Aye.
Crawford, I. Doyle,
Aye.
Doyle, I. Johnson,
Aye.
Johnson, I. Lara,
Aye.
Lara, I. And Pena.
Aye.
Pena, aye. That's all in favor. Motion passes.
Yes, thank you. In the matter of case post 2311373, Julio Colnetta, who at the time of the events in this case and is still employed by Los Angeles Police Department. Board have any comments? Ms.
I
Crawford,
move to, I make a motion to decertify.
is there a second?
A second.
Laura, second. Roll call.
Yes, thank you. Clavo,
Aye.
Clavo, I. Crawford,
Aye.
Crawford, I. Doyle,
Aye.
Doyle, I. Johnson,
Aye.
Johnson, I. Lara,
Aye.
Lara, I. Pena,
Aye.
Pena, aye. That's all in favor. Motion passes.
Thank you. Next item is post 2507337, Matt White, last employing agency Sacramento County Sheriff's Office and is currently employed by Sacramento County Sheriff's Office. At this time, I call upon law enforcement consultant Richard Collins in Professional Conduct Northern Bureau and Brian Henley, attorney, Legal Affairs Bureau, to provide a report on post 2507337, Matt White, who is employed by the Sacramento County Sheriff's Office. Mr. Collins?
Good morning, Chair and members of the board. My name is Rick Collins, and I am one of the law enforcement consultants assigned to the Professional Conduct Northern Bureau in the Peace Officer Standards Accountability Division. With me today is Bryant Henley, an attorney in our Legal Affairs Bureau. I'm here today to present case number post 2507337 involving Deputy Matt White, who at the time of the incident was and still is employed by the Sacramento County Sheriff's Office. It is the division's determination that clear and convincing evidence exists to demonstrate that Deputy White committed an act of serious misconduct as set forth in Penal Code Section 13510.8 on August 4th, 2024. Specifically, the division has determined that Deputy White committed the following act of serious misconduct: acts that violate the law that were sufficiently egregious and or repeated as to be inconsistent with a peace officer's obligation to uphold the law or respect the rights of members of the public. In this presentation, I will present a brief outline of the division's findings of investigation into this matter. Deputy White began his career with the Sacramento County Sheriff's Office on September 5th, 2004. Deputy White holds the following post certifications: basic, intermediate, and advanced. Deputy White had 3 complaints during his career dating back to 2016. One was for discourteous treatment, which resulted in an exonerated finding. The other 2 were for conduct unbecoming an officer related to his 2016 and 2024 DUI arrests. According to Sacramento County Sheriff's Administrative Investigation Report 2016 PSB-158, relating to the 2016 incident, Deputy White received a 160-hour suspension without pay, of which 80 hours were held in abeyance for 1 year. Sacramento County Sheriff's Administrative Investigation Report number 2024 PSB-0421, pertaining to the 2024 incident, states Deputy White received a 160-hour suspension without pay and was reassigned to a non-driving assignment in the jail facilities. On August 4th, 2024, Deputy White was arrested by a Folsom police officer for violating California Vehicle Code Sections 23152A, driving under the influence, and 23152B, blood alcohol content of 0.08% or greater. Deputy White's BAC measured 0.11% by volume. On June 11, 2025, Deputy White was convicted of California Vehicle Code 23152B, driving under the influence with a BAC of greater 0.08%. Sergeant Yates was assigned to conduct an administrative investigation into Deputy White's arrest for DUI. The investigation was submitted to POST subsequent its completion. During his administrative interview concerning the August 24 incident, Deputy White told investigators he thought he was okay to drive the night of his arrest. He said he fell short and made a mistake by having his last drink before leaving the bar. He admitted there was no reason for him to be driving that night and that his actions were not in line with department policy or the department's vision, mission, and values. He said his actions brought discredit to the organization. Additionally, he told investigators he started attending Alcoholics Anonymous meetings again after his arrest in conjunction with completing an alcohol treatment program in Southern California. Post Professional Conduct Northern Bureau interviewed Deputy White on December 18, 2025. The interview took place at Post headquarters. Deputy White's attorney, Joseph Hoffman, who is present today, was present for the interview in its entirety. Post and Joseph recorded the interview. The following is a summary of the interview and not a verbatim response to every question that was asked. Deputy White maintains he has not had a drink of alcohol since January 12, 2025. Since then, he has abstained from consuming alcohol. His efforts to stay sober are supported by weekly meetings with a counselor through an alcohol treatment program. Additionally, he attends Alcoholics Anonymous meetings once a week. His efforts are also supported by meeting with a counselor from the mandated 18-month DUI completion program, which he anticipates completing in February 2027. During the aftermath of his second arrest, he met with fellow employees who offered support and guidance for him. Deputy White does not maintain a log pertaining to when he meets with his counselors. At the time of his arrest in 2024, Deputy White's driver's license status was valid without restriction. At the time, he was working a North Patrol sector as a field training officer. He is currently assigned to the Rio Consumnes Correctional Facility. Although his driver's license is currently restricted, he has the ability to drive a county vehicle if the current administration were to sign a form acknowledging that Deputy White is required to use an ignition interlock device in his personal vehicle. If the administration signed the form, Deputy White could drive a county vehicle if it became necessary. On April 16th, 2016, California Highway Patrol Officer Furman arrested Deputy White for violating California Vehicle Code Sections 23152A, driving under the influence, and 23152B, blood alcohol content greater 0.08%. Deputy White's BAC measured 0.12% by volume. On July 16, 2016, Deputy White pled no contest to a misdemeanor violation of Vehicle Code Section 23152A. He was sentenced to 3 years informal probation and 48 hours of sheriff's work project. At the time of his 2016 arrest, Deputy White was employed as a deputy sheriff.
The Sacramento County Sheriff's Office initiated an administrative investigation into Deputy White's arrest by the California Highway Patrol. Sergeant Marcus Gregory conducted an administrative investigation. That investigation was submitted to post subsequent to its completion. During his administrative interview, Deputy White told the investigators he was aware that alcohol was a little bit of a problem in his life. He said he was introduced to Alcoholics Anonymous in September of 2025, where he attended meetings off and on. He continued by saying that he had been sober for 45 days prior to his arrest in April 2016. Since that arrest, he went back to AA, found a sponsor, and abstained from alcohol since the arrest. He also expressed the feeling of embarrassment he had for himself. The facts I've just recited support the division's finding that Deputy White was involved in serious misconduct, specifically acts that violate the law. For the purpose of the division's analysis, clear and convincing evidence means evidence of a charge that is clear and convincing so long there is a high probability that the charge is true. The evidence need not establish a fact beyond a reasonable doubt. The division recommends that Deputy White's post-certification be suspended or revoked. The division's recommendation is based on the following. The clear and convincing evidence substantiated that Deputy White engaged in conduct that led to his arrest and convictions for DUI in 2024 and 2016, respectively. Impaired driving is illegal due to the innate dangers to the drivers themselves and the public as a whole. Under Penal Code Section 13510.8 B6 and Post Regulation 1205 A6, acts that violate the law constitute serious misconduct when they are sufficiently egregious or repeated as to be inconsistent with a peace officer's obligation to uphold the law or respect the rights of members of the public. Impaired driving and repeated acts of impaired driving are acts that violate the law that are both sufficiently egregious and repeated as to be inconsistent with Deputy White's obligation to uphold the law or respect the rights of members of the public. As an officer charged with enforcing DUI laws, Deputy White's actions in driving impaired on 2 occasions establish that he committed serious misconduct. With that, I am happy to answer any questions that the board may have.
Board have any questions or comments? Ms. Clavo?
Does he currently have an ignition interlock on his personal car? Do we know?
Yes.
Okay. Ms. Pena?
So currently, what is his, the department has he been suspended? Has he served that suspension yet?
Yes.
Okay, and so how long, under the current situation that the department has imposed, how long will he remain with an interlock device?
He'll remain, that's a good question for his attorney to answer, and his attorney is present today.
Okay. And he's still in AA, as far as you know?
As far as I know.
Thank you.
Johnson?
Johnson?
Yes. Maybe clarification. Did he say that he was off and on going to AA meetings? Did I hear that earlier?
You did hear that, and that was prior to his 2016 arrest. Or after his 2016 arrest.
After, so he was off and on going to meetings after 2016 arrest?
Yes.
Seeing no other questions, I know Deputy White is here, as is his attorney, Mr. Hoffman. You'll each be given 5 minutes to speak, and the time limits will be strictly enforced, so please ensure that you complete your comments within the allotted time. While commenting, keep in board the board will only consider the facts as presented by the division today and will not consider any additional facts or defenses at this time. The sole question before the board today is the following. If the facts offered by the division today are in fact proven at a later hearing, do those facts demonstrate a high probability that serious misconduct, as defined in Penal Code Section 13510.8 and the Commission's Regulation 1205, occurred? Deputy White and Hoffman, welcome.
Thank you.
Morning, Chair and Board. My name is Joe Hoffman. I've been Matt White's attorney for the last 2 years through his court case, administrative discipline case with the Sacramento Sheriff's Department, as well as with the, thank you, DMV. I have a few very brief comments this morning about some facts and circumstances about the case that are going to be relevant to the board's recommendation. A couple things of note from his 2016 and 2024 cases. We have 2 cases about 8 years apart. In both instances, Matt was respectful and cooperative with law enforcement. In both cases, his blood alcohol level was not high, was just over the legal limit. And in neither case was he driving at excessive speeds or in a way that we normally identify as reckless driving. In the most instant case, he indicated that he felt fine to drive. He did not intentionally drive. Again, there are instances of driving under the influence where people are so high above the level they know they are. And unfortunately, alcohol impairs people and they don't always know when they're impaired due to the impairment. However, Matt recognizes that he, like many people, should not have any amount of alcohol, and Matt's going to address the proactive steps he's taken, such as a 45-day residential treatment, where he was away from his 23-year career as well as his young family to ensure that this never happens again. And the information is a little thin in the material, so he'll address that. He'll talk about his aftercare treatment. And most importantly, he'll talk about how this is different than the 2016 instance in the treatment that he's received. For Matt's conduct, in the most instant case, he was demoted. He was moved to the jail for 5 years by the Sheriff's Department. He received 14 days of jail for which he could do alternative sentencing. He has an 18-month DUI program where he meets once a week on his Saturdays. He has an ignition interlock device in his private vehicle for the next 1.5 years. He's not driving a vehicle through work because he's working in the jail for the next 5 years. I will note that Matt has no prior discipline with post. During his 23 years in law enforcement, he's worked as a detective, he's worked patrol, and his discipline is limited to these 2 incidences 8 years apart. Presently, Matt's working in the jail, and he's looking forward, hopefully, to the opportunity to continue to work in the jail and to redeem himself. The commission will review all recommendations by the board, and ultimately, Mr. White is hoping for an opportunity at probation and to comply with terms that are consistent with his sustained sobriety over the last 1.5 years. We are requesting the recommendation include a request that the commission consider probation and a recommendation that reflects that officers are human beings with real life problems, and it's up to the individual to take responsibility for their faults, which Matt has done. And ultimately, we ask for a recommendation that reflects that over the last 1.5 years, Matt has made consistent commitment to his sober life, and we believe that a recommendation would be just that's consistent with usable. Thank you.
Deputy White.
Good morning, board and board members. Let me just start to say thank you for your time and your consideration, and also thank Investigator Rick Collins. He's been nothing but professional and courteous to me throughout this process, and you guys have a great employee with him. We are here today because of me. There's no one to blame. There's no one to fault. There is a complete, utter embarrassment of shame that I brought to my profession, and above all, my truly loved Sheriff's Department. I've served the Sheriff's Department for 22 years, and it's, in my opinion, the greatest law enforcement agency in the United States. I absolutely love them. And to know the embarrassment that I brought to them because of my own personal problems still bothers me today. But since those problems, I've addressed these things to make sure that this will never happen again in my life. And the craziest thing I'm going to say today is that in August 4th, 2024 was the best thing that ever happened to me. That's the hardest lesson I had to learn. It has led to a better life, a better sobriety of life. And not only did I take that motivation, I made sure to put stipulants in that to make sure that there's a staple. And one of those big staples was, of course, AA. And then also I have a sponsor right now, but I think the biggest advocate was putting myself into a rehab down in Southern California is directly for first responders. It's the only one in the United States. It's strictly for fire and law enforcement and dispatchers. It was a challenge to have a new family and to be away from them from 45 days, but it was to better myself and better my life. And I think the biggest question or the biggest answer I have hopefully for you today is what's the difference between 2016 and now is I got therapy. AA has been wonderful. I've had grant, but I meet with a therapist. Though I have not documented the AA meetings, I strictly have documented every week I've met on Zoom with the therapist that I met in my rehab. Every week for the last year and a half, except for 2 weeks, I have met with her. And that has remained my sobriety. And sobriety to me was admitting that 22 years in law enforcement takes a toll on people and it takes a toll on your personal life. And I'm proud to say that, as you've heard, in 22 years, I don't have a sustained complaint except this. And I would like to really present again the value that I have again from 2024's arrest that is probably honestly saved my marriage, saved my life, saved my relationship with my family, and it brought above all pride back in myself of how to address problems. And I've been on a mission since then to redeem myself, quote unquote, to get to work, to be the change, to be the employee that I need to be, from subjecting myself to plenty of fines and penalties, not having a driver's license. At one point, leaning on 5 to 7 coworkers to give me rides during the week. For almost 5 months, I rode a bicycle for 5 miles each way to get these rides. And been injured during this last year and a half, but I did not deter from my mission of being at the sheriff's department and being a part of that. I think I'll end with, I love my sheriff's department and I love my profession and all that it's giving me. And no other consequence has been more hurtful or personal to me than having my peers have to stick their neck out for me. I think one of the biggest compliments, but yet slate of hurt, was knowing that my department did stick up for me and said, to this day, maybe outside of my father complimenting me at a time or two, the best compliment I've ever had was from a captain who said, your career was saved because of your service and your reputation. And since that fueled the aspiration to continue to be a change. 22 years when I started this, DUIs look different. Law enforcement look different. And I want to spend the remaining of my job teaching these newer employees the pitfalls of alcohol, pitfalls above all of driving, the dangers of that. And I would like to end by simply saying again, thank you. And thank you to Rick Collins. I hope that you will consider probation where I can continue to work and continue to be that change. I don't think I had a cop problem. I had a drinking problem. And I believe I've taken every step possible to try to correct that. Thank you for your time.
Board questions, comments? Ms. Claudia?
I'll make a comment. I commend you on your sobriety. I commend you on sitting here and taking responsibility for the role in which you played. I do have a problem with your attorney starting off with, it was not high, just over the legal limit. I have a problem with that statement, sir. We as citizens are not afforded the same rights in which police officers are afforded. And I'm right down the street from RCCC. Elk Grove PD has checkpoints on bond every other month. They just had one 2 weeks ago or within this last week. And if I would have got stopped there over the legal limit, I don't have this arena to appeal to. So for your attorney who's representing you and to start off with an excuse is really bad taste to me. The alternative sentencing. So it's my understanding that for 5 years you will be at RCCC.
Yes, that is correct.
And so, and that was since the conviction of July 11, 2025.
Correct.
So 2030 is when you will be able to go back on duty if it so chose.
You know, I'm sorry, I may have miscalculated the, I believe it's 2029.
2029.
Yeah.
Okay. And okay, that's all I have.
Ms. Pena?
So, how it will you, if this board didn't exist, how would you progress in your department? Like, what are you you'll continue at the assignment you're at now? And when would you get your license back, et cetera? I'm just curious.
Yeah, right now with I'm on DUI probation criminally, and with that comes an 18-month program. With that, I meet with counselors and also have meetings every Saturday for 2 to 3 hours. And is the question, if this board didn't exist, what
would your life look like in the department going forward?
It would be remaining at the jail. They have a policy, and also which I fully support, that if you're on DUI probation, you would not be in field services, and I would absolutely agree with that.
And how long does the probation last?
It is 18 months.
Okay, so after the probation, what happens?
I would still be restricted by the sheriff's department by my discipline until they lifted that in 2029.
Okay.
That is my understanding.
Okay. And the facility that you went to down south, was that a private facility?
It was, and thank you for asking that, because it's something that I paid for myself. It's paid for something that I went into my own leave to be there. It's very, very prominent, and they have a stat that 94% of their patients have returned successfully to work. And there was neuroscience that they did, that you had conducted to address PTSD. That's where I fell in love with therapy. I met with a therapist that I continue to do with, and it was 9 hours a day for 45 days. I would have stayed there 90, but I had a family and other obligations.
What's the name of the facility?
First Responders Wellness. It's in Newport, California.
Okay. It's interesting. And then so you continue to meet with a therapist now?
I do.
And is it a social worker, or is it a psychologist?
It's a trauma and addiction therapist that was worked for that First Responders Wellness, where I met her, and she's an addiction and a trauma therapist.
Okay. And then you continue to have a AA sponsor as well?
I do.
And how often do you interact with that person?
I interacted with them probably every couple of weeks. The biggest challenge I have going back to the jail is they work 12 hours and I live over an hour commute. And then with a small family, I have days of 14, 15 hours a day. And so to presently be at a meeting has either been on Zoom or whenever possible. But just because my sponsor may have interacted, and there's plenty of support throughout that program that has been very helpful to me.
Have you worked the steps?
Yes, I have. Yes. And Yeah, it was, the tricky part was I went through a couple sponsors to get to the end. And, uh, I think the biggest thing that I addressed earlier was from 2016 was, though I'm appreciative of AA, for me personally, therapy was the biggest, salute to sobriety that I have.
Thank you.
Thank you.
Crawford?
I'd like to commend you as well for being here, and it seems you are taking accountability for alcoholism is a disease. And I don't think a lot of people recognize it is a disease. And due to legislations, as you know, Member Clavo stated, not many people are afforded what you're getting. And one of the things that I really appreciated, you said, you know, on the day that you were stopped, that was life changing. It was a godsend. Not probating your words, sorry.
darn
But
near.
in this process, you mentioned that you're going to continue, hopefully educate young officers. I do believe that the job is stressful. I, in fact, was just talking to my sheriff in Ventura County about having places of mental health for officers with DUIs. I guess my question to you is, if this board was to, you know, two ways, I just really hope if they decided to decertify you, would you stop? Or if they decide to put you on probation, would it still continue your, you know, your journey of helping others? Because a lot of times we're seeing in crimes, we're seeing in the job places, in this environment, alcoholism is real. Like I said earlier, it's a disease. So I guess would you still continue?
Yeah, I'm going to be very personal with you. I'm glad you asked that because, in the process of building up for a mission like this and to be in front of a board, I've made, lack of terms, making peace with whatever decisions my superiors make. And my motivation for probation is where I can continue to address the employees that I have. And I know and I recognize that if I'm not in a position to that, I will continue to do that. I recognize that whether you said the good Lord or that was the best thing that ever happened to me. And I have some obligation to continue to be a change. And for me, my passion has been law enforcement. And I agree with you that is a stressful job. And I think we should be proud of the progress that is made during this time, but there's so much more to go. And boy, some of the challenges these younger guys have is immense. Probably a little bit double my mind. So to answer your question, absolutely, there's no way that I wouldn't.
Johnson, you have a question?
Yes, Johnson. So I believe your attorney had stated that you weren't driving erratically, you weren't speeding, you didn't put anyone in danger. But I believe to our understanding, according to the law, anytime you drive while intoxicated, you are violating the law and putting others at risk. And if you had been driving perfectly, we probably wouldn't even be discussing your name today because you would have
100%.
never been pulled over. So it's pretty obvious that you was, under the influence and driving erratically. I just wanted to clarify that. But under Penal Code Section 13510.8B6, repeated violation of the law that are inconsistent with a peace officer duty constitutes serious misconduct. This case meets that standard.
That it does.
Okay, so we're here tasked to follow the legislation based on an offense that has been repeated and egregious and has put the public at risk. I believe today you're asking us to have some mercy, which I'm sure you're asking, but we are required to follow SB2 legislation. And the reason why this SB2 passed for situations just like this, for too long, for too many years, we know alcohol has been a problem within the policing agency. And many has went to recovery, kept their job, and lived life. But that law changed that. And so we have to consider what the law says.
And I'm actually thankful that that law has changed. And I'm thankful that you addressed that. And I do understand that. And I think it's difficult at some point to say, I am asking for mercy or the grace or spirit of my potential compared to what I've been. And one of the first questions I had learning to post in these hearings is why is there a hearing? Why is there you guys have this? Because you're right. There's no ifs, ands, buts. I violated that twice. And for that, I guess I would say I am redeemable and would like to make a change and continue to be that change. But I respect your opinion and decision regardless of what that my personal feelings may be included in this.
Just have one more comment.
Sure, go ahead.
We've had many come before us in the same similar situation you're in. And one of the things I appreciate your candor and how sincere you are about doing your job. So I just want to leave in spirit with you, whatever we decide as a board, I pray that you continue and you have a calling. And if that calling is setting up a nonprofit, whatever, and maybe I'm out of line, helping others, I hope that you do that.
Yeah.
Deputy White, just for clarification, during the whole process, do you believe you were treated any differently because you're a peace officer as opposed to someone else that was not?
During post?
No, I mean, you were arrested twice. No, you were arrested twice, and there was a comment made that somehow you were treated differently. Do you feel you were treated differently than anyone else that would be arrested for DUI?
No, the day I showed up at work project and with my peers and my coworkers, I knew I was not being treated differently. When I sat in that holding cell for 7 hours, I knew I was not treated differently. One of the things that I wanted to add to this was not being treated differently, but one thing that I did do differently was when I was pulled over by the Folsom police officer, he apologized to me, but I was quickly to remind him that I had put him in that situation. I respected his decision regardless of what happened. And he even offered a point to have a ride pick me up at the Folsom Police Department. But that was later. My ride did show up. And it was later determined by all parties that no, I would go be booked in the Sacramento County Jail, my jail that I've worked for.
Okay, thank you. Any other comments or questions by the board? Thank you.
Mr. Doyle, may I make one comment? I'm
Sure.
sorry, did you want to say something, Brian?
You may have the same point, and I'm happy to defer to you, Assistant Executive Director.
It just speaks to Board Member Johnson's comment about your obligations under Senate Bill 2 and acts that violate the law. And all of you have before you the disciplinary guidelines that were adopted by the commission. And I would just note page 15, acts that violate the law establishes minimum, maximum penalties that you can consider. Very last paragraph says, in cases where alcohol or substance use has resulted in or contributed to a violation of law, even in some instances of repeated or egregious violations of law, a term of suspension and or probation with optional terms and conditions relating to abstaining from alcohol and substance use and participating in regular testing may be appropriate based on the rehabilitative efforts of the subject officer and the lapse of time since the alcohol or substance use and violations of law occurred. So again, it's something you can consider. I just want to make sure it's on the table. Again, it can be revocation in situations where the recommendation to the commission would be something other than that. It would be considered a revocation stay and a consideration for some sort of suspension and probation. Thank you.
Do you get tested by the department?
I've never have been tested, but I believe there is a legal process through Eternal Affairs, but I'm not aware of it. I've not been tested.
And through the court, are you tested at all?
No, I'm not actually, but I do have a active breathalyzer, which tests me every day when I drive.
Right, okay, thank you.
Is there anyone from the public who would like to address the board at this time? When it is your turn, you may state your name and organization if you wish. You will each be given 3 minutes to speak, and the time limits will be strictly enforced. So please ensure that you complete your comments before the allotted time. Is there anyone from the public that would like to speak? Yes. Mr. White, you don't have to stay.
Good afternoon, board and chair members. My name is Morgan White. I am Matt White's wife and the mother to our 2 young children. I want to reiterate the work that Matt has done on himself, how proud I am of him, and the impact that this DUI has had on our lives. It has made our lives, no matter how absurd it sounds, better. It has been better for our family, and the accountability that he has taken in the last 2 years since this incident has been incredible. His sobriety alone has made him a whole new man, and it has also led to my sobriety, which has led to our sober household, realizing that raising our family and showing our children that sobriety is a better lifestyle he has taken accountability and has made changes in his life. We have, as a unit, have made changes into our lives. When Matt went to rehab, he was away from myself and our 1.5-year-old son for 45 days. That was a huge step for him to take, not only for himself, but for his family and for his career. I want to emphasize that all the steps that Matt has taken since his DUI were first for himself, second for his family, and third for his career. He is proud to be a Sacramento Sheriff's Deputy, and I ask that you consider the effort, the changes to his life, and the accountability that my husband has made to better our lives in your decision. Thank you very much.
Thank you.
Thank you.
Anyone else who would like to address the board? Please come forward.
Hello, my name is Arleta Nance. I'm the mother of Tamon Wilson and Thomas Wilson, killed by the Martinez police August 18, 2023. Does POST have any, like in your training of officers, do you guys have where they can get tested for steroids and alcohol? That's a question I have.
That would be incumbent upon the department as part of their employment. but Law enforcement agencies do have random drug testing, alcohol testing. Yeah.
I just wondered if it was a part of the training, because you see a lot of officers look kind of juiced up and they act very erratic and talk like robots. So I know that's a part of steroid use. So I was just wondering if it was in you guys' training.
Again, it's the employment side of things. From the post perspective, as far as part of a probationary term, drug and alcohol or substance abuse testing is part of the probation.
To
Yeah.
whatever agency they employed by.
And steroids is one of many things that can be tested. Yes.
Okay.
Thank you.
Like to address the board?
Good afternoon, Beatrice Johnson. I wrote this. I stand before you not just as a community member, but as someone whose life has been permanently impacted by drunk driving. My sister, Dorothy Jean Dale Chamber, and other family members were killed by DUI. The officer also stated that he thought he was able to drive. I want to be clear, everyone who gets behind the wheel after drinking says that. That belief is not unique. It is not a defense. It is a very mindset that leads to tragedy over and over again. So when I hear this officer say, I don't have a cop problem, I have a drinking problem, it does not sit well with me. It raises serious concerns. The statement attempts to separate identity from responsibility, but the reality is you cannot separate the two when you are sworn to protect the public. By calling a drinking problem, the officer is calling it a drinking problem. The officer is reframing the issue in a way that reduces accountability. It shifts focus away from what this actually is: an abuse of authority, poor judgment while entrusted with power, and a direct risk to public safety. Being intoxicated while in a position of authority is not just a personal issue, it is a policing problem. It affects judgment, it affects decision making, it affects how force is used, and it damages public trust. Alcohol does not excuse behavior, especially for someone who carries a badge and has the responsibility to protect lives. There is also an underlying message in that statement that cannot be ignored, an implication of, I'm not like those people, I just had an issue. But from where I stand, as someone who has buried loved ones because of decisions made under the influence, there is no separation like that. The consequences are real, the harm is real, the loss is permanent. And a drinking problem does not make this less serious. It makes it more dangerous. Because when someone with authority makes impaired decisions, the risk to the public is even greater. This is not just about one officer. This is about the standards we are willing to uphold. Accountability must be clear, the line must be firm, and public safety must come first. And I just want to say that officers are not above the law. If it seems like that he got a lesson out, I think he would be better as a civilian working in the police department, helping officers so they don't drink. But I really just feel like that officers are not above the law, and we have to stop now with allowing them to do that, be above the law.
Thank you. Any other comments from the public? Seeing none, at this time, does the board wish to adjourn into private deliberations? Yes, okay. Meeting will adjourn into closed session for deliberations on the case, and we'll be back as soon as we're done. Thanks.
Your lunch is ready, so you'll be
In the matter of post case 2507337, Deputy Matt White, who at the time of the events at issue of this case was and still is employed by the Sacramento County Sheriff's Department. And do board members have comments before we take a vote? Ms. Pena?
Yes, thank you, Mr. Chair. I just want to say, I think this is maybe the first DUI case that we've considered that I do not plan to vote on revocation, because I do think DUIs are very, very serious, particularly for police officers. But in this instance, the thing that distinguishes it from the other cases that have come before us is the officer has shown remorse and taken accountability from the get-go. From the moment that he was pulled over by the officer, he didn't blame it on somebody else. He didn't try to make excuses. He took responsibility for it. And since that time, he's on the 2024 stop, I think it was, he's taken responsibility, has sought out and received, gone to a rehabilitation class down in Southern California for 45 days at his own expense. He attends AA meetings, and I hope he continues to attend AA meetings. He's worked the steps. He has a sponsor. He does regular therapy, which I think is fabulous. I think everybody should be in therapy. And so for these reasons, and he has not made excuses about, well, I've been under stress because of this or that. DUIs and alcoholism is a very personal thing, and nobody can help you but yourself. And he has taken it upon himself to take responsibility and is doing everything in his power to make sure that it doesn't happen again. And so for those reasons, that's why my vote will not be for revocation. Thank you.
Crawford?
I would like to say that, as well as my board member, Margaret said, DUIs are something that is very serious. And just as the public and as a community, we expect the same thing from our officers as they expect from us. But there are some times that, we are compelled by looking at other facts and making our decisions that we make. And so I hope, if anything, the officers learn from this officer, this is not something that will be continually acceptable in the minds of the community of how we want our officers, because they stand at a higher standard than most. And I will always argue that make it equal and fair. But this officer did show of some things we hadn't seen in the past. So I will also be taking that in mind when we vote.
Mr. Laura?
I haven't commented.
Ms. Clavo?
This is a very difficult decision for me today. As I've said in our DUI cases in the past, I'm hard pressed for DUIs. And I really don't care what your profession or who you are. DUIs lead to tragedies. Tragedies lead to deaths. I do still commend you, and as I believe Ms. Pena and stated, I did feel your remorse. I did believe you. I do believe that you mean well in your progression of your sobriety. So we'll see.
Gotcha.
Yes. Oh. Well, this case meets SB 2 standard because it involves unlawful conduct that demonstrates a pattern inconsistent with the judgment and responsibilities required of a peace officer. This is not a single lapse of judgment. It is a repeated decision to engage in dangerous, unlawful conduct that put the public at risk. An officer who twice chooses to drive impaired has demonstrated a willingness to place the public in danger. I am, of course, hard pressed when it comes to a repeated act of violating the law. And at some point, feel we have to take a stance in a position of what accountability truly looks like. And I'll pin my comment there.
I'm prepared to make a motion. I propose a 3-month suspension, stayed provided Deputy Matt White agrees to participate in a probation program determined by post staff. Is there a second?
I'll second the motion.
You have a motion and a second. Take the roll.
Clavo.
Sorry, I didn't hear my name. I'm going to abstain.
Clavo abstention. Crawford.
Aye.
Crawford, aye. Doyle.
Aye.
Doyle, aye. Johnson.
Nay.
Johnson, nay. Lara.
Aye.
Lara, aye. And Pena.
Aye.
Pena, aye. That's 4 in favor.
The motion passes.
Mr. Vice Chair?
Yes.
If I may, for a point of clarification,
Sure.
just for the record for the commission in terms of this recommendation. So I understand that the motion was 3 months of suspension stayed, subject to a period of probation. How long would the period of probation go for? Just so the commission can be aware of the recommendation.
I don't think we talked about a time. We knew that there has been a program established by the Post Commission.
And without any, not leaning either way,
Sure.
but my understanding in prior cases that the commission has had where they've done a revocation state. Obviously, we're doing things differently here. This board is doing things differently, but the period of probation has been for 5 years. But that isn't necessarily what this board would need to recommend, but by way of, just for context, in other cases, I believe 5 years has been the period of probation. And I will just check with our Assistant Executive Director, Ms. Del Munayo, a 5-year period of probation, is that consistent with what we've seen the commission provide in prior DUI cases, double DUI cases?
It is. I think that's more of a standard. It can range from obviously anywhere from 3 years to 10 years. But what we've seen most often in our DUI cases is a period of 5 years of probation with standard terms and conditions, including substance abuse monitoring, sometimes counseling, and other what we call standard terms and conditions. They have to obey all laws. They cannot, they can't drink at all. It's not just while on duty. So it's complete abstention from alcohol. And our substance abuse testing protocol is not limited to certain days of the week. So they can be tested 7 days a week while on vacation, while off duty, etc.
And Mr. Vice Chair, sorry, last comment, if I may. As this board is aware, and as Ms. Del Munayo made clear earlier today, the commission recently adopted disciplinary guidelines. Those guidelines include the so-called standard terms and conditions that Ms. Del Munayo made reference to. Those terms go from numbers 1 through 15. And then there are a number of optional terms and conditions, which are, they start at number 16 and go through 25. So depending upon this board's will, they could select among the standard and as well as the optional terms if they wanted to in the recommendation, or perhaps this board wishes to abstain from those types of recommendations. But I wanted for context to make clear that those guidelines exist and are available to this board should they wish to select the terms and conditions of probation.
Now, I think when we discussed this, it was intended to leave it up to post staff to determine the length of a suspension.
Thank you, Mr. Vice Chair. I appreciate that.
Okay. Okay. Can you move on? All right. Okay. Thank you. Next up is post 2322062, Hector Victoriao. Last employing agency was San Bernardino Police Department, and he's currently, I think, still employed as a community service officer. At this time, I will call upon Consultant Michael Marshall, Professional Conduct, Southern Bureau, and Carrie Woodley, Attorney, Legal Affairs Bureau, to provide a report on Post 2322062, Hector Victorio, who at the time of the events issued at the case was and still is employed by San Bernardino Police Department.
Okay. Good afternoon, Chair, members of the board. My name is Michael Marshall. I am a law enforcement consultant assigned to the Professional Conduct Southern Bureau in the Peace Officer Standard Accountability Division. With me today is Carrie Woolley, an attorney with our Legal Affairs Bureau. I am here today to present case number Post 2322062 involving Hector Victorio with the San Bernardino Police Department. It's the division's determination that clear and convincing evidence exists to demonstrate that Hector Victorio committed an act of serious misconduct as set forth in Penal Code Section 13510.8 on November 27th, 2023. Specifically, the division has determined that Hector Victorio committed the following act of serious misconduct: physical abuse to include excessive or unreasonable use of force. In this presentation, I will present a brief outline of the division's findings of investigation in this matter. Hector Victorio began his career with the San Bernardino Police Department on September 16th, 2021 as a trainee. On March 14th, 2022, he was sworn in as a peace officer. The position is defined as a peace officer under Penal Code Section 830.1A. On November 5th, 2025, Hector Victorio was demoted to the position of community service officer. Hector Victorio holds the following post certification: Post Basic Certificate, which was issued March 22nd, 2023. The respondent has not been the subject of any other internal affairs investigations regarding the use of force, nor does he have any prior history of allegations of unreasonable use of force being filed against him. However, on February 22nd, 2024, the San Bernardino Police Department received a complaint from the San Bernardino District Attorney's Office about an incident that occurred on October 28th, 2023, concerning Officer Victorio's discourteous treatment of an arrestee during a burglary investigation. In addition, in May 2025, the San Bernardino Police Department received a complaint that was submitted by mistake to the San Bernardino Sheriff's Department about a vehicle stop and a residential search that occurred on April 28th, 2025. As a result of these incidents, Officer Victorio agreed to a demotion to a non-peace officer position as a community service officer on November 5th, 2025. California Penal Code 13510.8 B3 and California Regulation 1205A3 defines as serious misconduct physical abuse, including but not limited to the excessive or unreasonable use of force. On November 27th, 2023, San Bernardino Police Department Officer Hector Victorio and his partner were assigned a two-man proactive patrol in a marked unit in the city of San Bernardino. Officer Victorio was the driver, while his partner was the front passenger. Officer Victorio attempted a traffic stop on a Kia without a front license plate. The vehicle failed to yield and a pursuit was initiated. The pursuit lasted in excess of 6 minutes and reached speeds of over 100 miles per hour, passed through a school zone, crossed into oncoming traffic, and went through intersections without yielding the right-of-way. The pursuit ended when the Kia crashed into a utility pole. The suspect driving the stolen vehicle, hereafter referred as to victim, immediately exited the vehicle and laid face down on the ground with his arms above his head, palms down on the ground in the prone position. The victim had a cell phone and a cash bill in his right hand. Show a picture. So here's a picture from the body-worn camera as Officer Victorio approached. Officer Victorio ran towards the victim while yelling, quote, "Get the fuck on the ground," end quote. The victim responded, quote, I'm on the ground, bro, I'm not resisting," end quote. As Officer Victorio approached the victim, he immediately began striking the victim in the head with multiple knee strikes, after only telling the victim to, quote, Get the fuck on the ground, end quote. On 3/24/2026, the San Bernardino Police Department submitted additional evidence, which included a video of a sergeant's administrative interview with the victim shortly after his arrest. The victim told the sergeant, quote, "I got out of the car and I instantly got on the ground. I knew that I was running from the police and I knew that I crashed into a pole. And the next step was to get on the ground and I got on the ground and the first thing they did was come up and knee me." This statement from the victim was never documented in the IA. The statement is consistent with the initial reaction by the victim when approached by Officer Victoriao. The victim is heard grunting in pain and moved his hands from the ground above his head to protect his face. Officer Victoriao followed the knee strikes with multiple punches and more knee strikes to the back of the victim's head and neck. Officer Victoria's partner was on the victim's back trying to gain control of the victim's hands in order to apply handcuffs. The victim kept moving his hands to protect his face from being struck by Officer Victoriao. The entire encounter lasted approximately 19 seconds from the time Officer Victoriao reached the victim until Officer Victoria's partner was able to apply handcuffs. During this time, Officer Victoriao delivered at least 6 punches and at least 6 knee strikes to the victim's face, head, and neck. One of the knee strikes was delivered to the victim's face while Officer Victoriao placed his hands on the victim's head to pin it to the ground. At one point during the encounter, Officer Victoria's partner used his hand to block a punch from Officer Victoriao and then moved his body as a shield between Officer Victoriao and the victim. The assault ended as the supervisor arrived on scene and they were able to take the victim into custody. There were 2 different videos of the incident. One video was Officer Victoria's body camera, and the second video was a witness filming from a cell phone. On the body-worn camera, you can hear the officer and his partner telling the victim to stop, give me your hands, and quit resisting multiple times. The victim responded by saying, "I'm done and I'm sorry." Go to the next, we'll show the first video.
Just before we show the video, Mr. Marshall, if you will, just as a general caution, you may be seeing things here that are disturbing, sensitive, violent. Just cautionary if you do not care to watch. Thank you.
Get on the fucking ground! Stop resisting! I'm not moving, come on, I'm not moving! I'm not moving! I'm not moving! I'm done! Give me your hand! I'm done! Come on, I'm done! Dude, give me your hand! Stop! Give me his fucking hand! Stop resisting! I'm sorry! I'm sorry! You got him, bitch? I'm sorry. I don't got nothing on me.
That's a video from the body camera. The next video will be from the witness cell phone.
Yeah. You should have been doing that.
So the last video is going to be this video zoomed in a little bit. Before I move on, if anyone needed to see a video again, let us know. The victim sustained a closed fracture to his left orbital socket, contusions to the left side of his face and forehead, lacerations to his lips, abrasions to the right side of his face, and a few chipped teeth. Pictures. The left orbital eye. Next picture. The abrasion to the right side of his face and his lips. Last picture. Chipped teeth. I also learned from additional video submitted late that the victim was questioned about the airbag being deployed during the accident, damaging his face. The victim said that the airbag did not hit his face because he saw he was going to hit a pole in front of him and he braced for impact. This statement was also not included in the IA. The San Bernardino Police Department determined at the conclusion of the administrative interview that Officer Victorio's use of force violated policy section 300.3, use of force. Officer Victorio received a 40-hour suspension with 20 hours held in abeyance upon completion of 40 hours of de-escalation techniques and use of force training within 1 year from the date of the signed settlement agreement, which was completed. On January 17th, 2024, the San Bernardino District Attorney's Office declined to prosecute Officer Victorio for violation of Penal Code Section 149 due to lack of sufficient evidence to prove beyond a reasonable doubt. On July 2nd, 2024, the victim signed a settlement agreement with the City of San Bernardino in the amount of $450,000. The settlement agreement compensated the victim for injuries he sustained during the November 27th, 2023 incident. The facts I just recited support the division's findings that Hector Victorio was involved in serious misconduct, specifically physical abuse. For purpose of the division's analysis, clear and convincing evidence means evidence of a charge is clear and convincing so long as there is a high probability that the charge is true. The evidence need not be established as fact beyond a reasonable doubt. The division's recommendation that Hector Victoria's post certificate be revoked or suspended. The division's recommendation is based on the following. Officer Victorio's actions constituted physical abuse when he used excessive force against a victim who was lying flat on the ground, surrendering, striking him at least 6 times with a closed fist and at least 6 times with his knee. Officer Victorio justified his use of force by stating that the victim was resisting arrest. The subject sustained abrasions to his face, chipped teeth, and a broken orbital eye socket during the incident. Officer Victorio completed his field training program approximately 14 months prior to the incident. Officer Victorio has been the subject of 2 other IAs, neither which involved the use of force and were not reported to post, including the allegations of serious misconduct. The division believes an aggravating factor in this investigation is approximately 1 month prior to the use of force incident on October 28, 2023, Officer Victorio was heard on body camera telling another victim who ran from him, quote, "You're so fucking lucky there's people here. I'd beat the fuck out of you for taking away from me," end quote. And can we play that video, please?
You all right?
Yeah, I'm fine.
You with me? Where's the knife at? Is it open?
No, está así.
One item 16. We have him detained. We're gonna get to the court here. You're so fucking lucky there's people here. I'd beat the fuck out of you for taking away from me.
Just back to
Did anyone need to hear it again? Are we good to move? Perfect. During that incident, Officer Victorio threw away the victim's backpack instead of booking it into safekeeping. Inside the backpack was the victim's personal property, 2 cell phones, suspected drugs, along with headphones in a box matching that of what was stolen during the commercial burglary. The backpack could have potentially contained physical evidence in the incident, but Officer Victorio chose to discard the personal property of the victim and not properly investigate the headphones or determine whether it was related to a commercial burglary. 1 month later, a victim ran from Officer Victorio, and Officer Victorio began punching and kneeing the victim as he laid flat on the ground, which led us to where we are today. Approximately 1 year and 5 months after the use of force incident, on April 28th, 2025, Officer Victorio conducted a lawful traffic stop. During this traffic stop, it was determined that the driver had a suspended driver's license and she had previous firearms-related offenses. Officer Victorio searched the vehicle and told the driver he would not tow her vehicle or arrest her if she let him search her house. The driver advised she had ammunition in a drawer in the bedroom. The driver gave permission to search the house, but was left handcuffed in the back of the patrol vehicle while the house was searched. Officer Victorio recovered the ammunition from the house. The driver later filed a complaint against Officer Victorio, at which time the department learned the ammunition was never booked into evidence. During the administrative investigation, Officer Victorio informed the agency that the bullets were in his beat bag and he booked them into evidence. Based on these incidents, Officer Victorio was demoted to a community service officer pursuant to a settlement agreement following the misconduct investigation involving violations of policy. With that, I'm happy to answer questions the board may have.
Board members? Seeing none? I believe Officer Victorio and his attorney, Casey Castillo, are here. Please come forward. You will be each given 5 minutes to speak, and the time limits will be strictly enforced, so please ensure you complete your comments within the allotted time. While commencing, keep in mind that the board will only consider the facts as presented by the division today and not consider any additional facts or defenses at this time. The sole question before the board today is the following. If the facts offered by the division today are in fact proven at a later hearing, do those facts demonstrate high probability that serious misconduct as defined in Penal Code Section 13510.8 and Commission Regulation 1205 occurred? So, welcome.
Sure. Good afternoon, members of the board. My name is Hector Victoria of the San Bernardino Police Department. I have dedicated 4 years of service, public service in the state of California. I am currently working in the role as a community service officer and recently was assigned as a training officer for new community service officers as I await the outcome of this process. Before joining the police department, I served 7 years in the United States Marine Corps and deployed 4 times overseas and then got discharged with an honorable discharge. During my police tenure, I have served in patrol operations, the SWAT team, and as a district resource officer for the city of San Bernardino. During my career, I have received commendations for good police work, including recovering more than 30 illegal firearms in just 3 months. But it is important for me that you know that I realize and feel that my good deeds and hard work are overshadowed and diminished when my behavior doesn't meet the high standards of excellence the community and the profession deserves. Regarding the matter currently under review, I want to provide professional context based on the training I received during the academy and at my agency, as well as throughout my career. I understood that my responsibilities and prioritize safety and respond appropriately to what I perceived at the time. The situation was rapidly evolving, and I was required to make a decision based on the facts as I perceived them at that time. At the time, I believed I was working too quickly and efficiently to effect an arrest. The internal review of this matter by my department led to the disciplinary action in form of a suspension, which I accepted without objection. I also have undergone 40 hours of de-escalation training. After reflecting on the use of force incident along with additional training I have received, I realized I could have reacted differently, communicated more clearly with my partner, and slowed down the situation. I understand the seriousness of the allegations as I respect the board's duty to maintain the standards of our profession. I accept and understand my force was deemed unreasonable on this day. I will perform better in the future, and I have performed better since then. Being a police officer is more than a job. It is my career, my commitment to the community. I have matured as a person and as not the same person or 1 year police officer in the matter before your consideration. I have continued my education and I am currently attending the DeVry University in Ontario, California. I currently hold a 4.0 GPA, made it onto the Dean's List, and was nominated for the National Society of Leadership and Success. I graduated with my associates in applied sciences in July, God willing. Because of this incident and the additional training I have received, I have learned to approach these high-stress situations a lot better. I have done this by slowing down, analyzing the situation as best as possible with the limited information that I have at the time, and allowing ample time for resources to arrive. Since this event, I have spent an additional 2 years on patrol and was put in similar situations, if not worse, and was able to resolve the situation with little to no force at all, and that is something that I am proud of. I commit to serving not only my community itself, but internally as a role model and example to other officers and my peers. Self-reflection and review can be a humbling experience, but one I am grateful for. Thank you for your time and the opportunity to speak to you today. I believe I can always do better to improve. I am strongly committed to continuing to serve with the highest standards expected of a California police officer. Thank you.
Bill, okay. Good afternoon, members of the board. My name is Casey Castillo of Casey Law Group. We represent Officer Victoriao and oppose the recommendation to move formal proceedings for decertification. Here, moving this matter forward would be premature for an individual without a history of force-related incidents before or after the matter for your consideration. I believe that the legal standard of clear and convincing evidence has not been met. Decertification requires clear and convincing evidence of serious misconduct, and that is a high bar. In excessive force cases, the question is whether the force was objectively reasonable under the totality of the circumstances, not whether it appears unfavorable in hindsight or in a slowed down replay. The record before you does not rise to the level of clear and convincing proof required to justify the most severe consequence post can impose. I believe that the force should be assessed and not in a vacuum. At the time of the incident, this officer had 1 year and 3 months on the job, and his subjective perception, where he prioritized a swift and efficient outcome, reflected the level of training, experience, and judgment he had at that stage of his career. To the extent the recommendation relies on a 0 to 60-30 or 60 theory, suggesting that the officer should have escalated more slowly or chosen a different sequence of options, that framing improperly demands perfection in a split-second high-stress encounter. The suspect had engaged in a dangerous and reckless 6-minute pursuit, often in opposite lanes of traffic during the school day. The vehicle was stolen. The suspect only stopped when he crashed into a pole, and even then he exited the vehicle without being directed to. Officer Victoriao admittedly did not recognize that the suspect was in the process of surrendering. At that time, he believed his actions were appropriate to gain and maintain control, protect the officer and others, and safely resolve that situation. The objective reasonableness standard does not require absolute perfection or best option in hindsight. SB 2 does not authorize moving toward decertification simply because a use of force is criticized after the fact. It requires that that showing was unreasonable under the circumstances at the time. And while Officer Victoriao believed there was a blunt object in the suspect's hand, his partner additionally joined him and had to assist in the handcuffing. Admittedly, their communication could have been better. Weapons for strikes when he was unable to secure the suspect. And although it was perceived by the investigator that Officer Rodriguez was using his hands and body to block, Officer Rodriguez denied that was the case. The San Bernardino County District Attorney's Office thoroughly reviewed this matter and determined that no criminal filing was appropriate. His agency determined that improper tactics and inexperience led to this unreasonable use of force, and he was suspended and sent to 40 hours of de-escalation training. The findings note a statement attributed to Officer Victoriao in an unrelated non-use of force incident, which occurred a month before the events at issue, but resolved after this case. De-escalation training was subsequently received by Officer Victoriao. Similarly referenced was another policy violation, which was also not one related to force, but searching months after the matter at hand. Officer Victoriao put himself through additional search and seizure training at his own expense.
These instances should not be used to bolster these proceedings and justify movement to formal proceedings. Decertification is not the only option. Hector Victorio told investigators that as he acted, he believed his force was reasonable at the time, but he has also readily accepted and embraced discipline without protest, as well as training both issued and self-sponsored to correct behavior deemed inappropriate. His missteps took place within a 6-month snapshot of his career when he had just over a little of a year on the job. Before you is an individual willing to learn, adjust, and perform to the highest standards. Please refer to the almost 20 letters of public comment from members of his department, specifically a captain, 2 lieutenants, 4 sergeants, and multiple peers who attest to his witnessed growth as an officer and as a person since the event before you. They have seen him absolutely humbled, but continue to believe in him as a contributing sworn peace officer, and he is endeavoring every day to prove that he is deserving of that title. For these reasons, we respectfully request that the board find there are no grounds for further action, decline to move forward toward formal proceedings, and close this matter. The board has a high bar to meet and satisfied to reach clear and convincing evidence, even in an unreasonable use of force case. But it has not been met, and should the board determine that action is appropriate, please consider an alternative to revocation. Thank you.
Thank you. Board have any questions of Castillo and Officer Victoria?
You were officer for 4 years.
I've served a total of 4 years for the department. I received my demotion back in November of last year.
November of 2025.
Yes, ma'am.
And so your actual, how long were you actually an officer?
I would say approximately 3 years.
And then
And then
at the time of the incident, it was 3 years?
at the time of the incident, I was just over a year and 3 months around there.
And then, I'm not for sure, but maybe, so I'm gonna ask for clarity. I heard since the event, there were similar situations in which you acted differently.
Yes, ma'am.
Was that in the capacity of a CSO?
No, ma'am. So after the incident, I was assigned to the records department for approximately 5 months, which is behind a desk doing all the administrative paperwork for the department. And then after that, I was allowed to go back into the field. So I was probably back in the field for a year and a half before getting demoted to a CSO.
Okay, thank you.
Yes, ma'am.
Laura?
Yeah, I got a couple of questions. So although your attorney says that the other incident that took place prior to the matter that it's at hand before us is not illustrative of your behavior and your patterns of conduct, I wanted to point something out. The argument is made that you, during the vehicle pursuit, rapidly unfolding, driving against traffic, stolen vehicle, that is a critical incident with that's very dynamic. And I having been in pursuits, I understand that. However, the other incident, which your counsel makes the argument that it's not related, that's an incident where the incident is not rapidly unfolding. The suspect is essentially already in custody, is completely, from all appearances, compliant, and in a clear head, because it's, to your attorney's estimation, not a rapidly unfolding event, you make this statement: you're so fucking lucky that there are people here, otherwise I'd beat the fuck out of you. How do you, in a situation where there's no criticality or exigency in that moment, which is comparable to the stolen vehicle that is at issue here, how do you square that as not being relevant to our decision here?
Officer Victoria.
Yeah.
For me?
That's for both of you.
Oh, for me. All right, well, I'll start. Thank you for your question. I believe that it's important to note that that statement was made and the record reflects from the internal affairs incident that was used to essentially dissuade that individual from making movements that would cause a use of force. Admittedly, Officer Victorio in that interview explained his behavior, but also explained the rationale behind that. Subsequent to that statement, as well as the incident before you, he received de-escalation training. And since then, he utilized those tools to better himself in the field and not make those mistakes again.
Yes, sir. So there's no excuse as to what I said that day, on that time. Prior to that, he had fled for me. He ended up being the suspect in a commercial burglary. Again, that's not an excuse for my actions. I understand now, and like I did then, that was wrong, which is why I accepted the discipline. And like Casey said, ever since then, all I can do is better myself and be the best version of myself. And I think that's what I've strived to become.
Vice Chair, if I may, address some comments that were just made. I need to correct the record. Actually, the statements that were made in October of 2023, they were not found to be made to dissuade that arrestee from taking off further. That's incorrect. That's an incorrect statement of the record.
My statement was what his explanation was in the interview.
That's not my understanding of the record, but it is part of the exhibits.
Crawford?
So to reiterate the purpose of SB 2, and I'm sure you've read the law and understand the law, and I think while emotionally during the chase, things escalate and things happen, but just as it's okay if I play Captain
Charles.
Charles stated, in another incident where it wasn't the adrenaline of the chase, the victim in this case was handcuffed. You then went on to make a statement. Again, I'm not an attorney, but we kind of learn that those type of statements can be used in a court of law as a threat, and to downplay it as I just wanted him to understand not to even try to run. I'm a community member, and as a community member, hearing that was disturbing because that's not my expectation of an officer. So given that you went through the training, you learned to change some things, my question to you, now I'm speaking to the attorney, is in belief, do you believe that statement, because you're an attorney and you've learned those type of statements can be sometimes criminal in a torts law or in some type of law when you make a threat towards a person? It is considered.
I don't mean to interrupt you.
Okay, no.
I don't believe that that was an unconditional threat. I also don't believe that that rose to the level of what would be considered a criminal threat under Penal Code Section 422. And again, the purpose in, I believe it being presented, but as well as us addressing it at this time, is to show that Officer Victorio, as a young, immature cop, when 1 year into his career, made mistakes, those which are obviously serious in nature, but nonetheless ones that he has grown from and has received training subsequent to. I personally believe that Officer Victorio is absolutely not the same person that I met 3 years ago. And I've seen how the discipline and the additional training and the fact of his demotion has changed the person he is. I do not believe that while serious revocation is appropriate in this matter, because this is someone who is capable of remediation.
I guess for me, like I said, as a community member, this is what people see. And children see this. And I don't know your background, your upbringing at any time. And I hope POSA's not training officers or the academies are training officers to believe at any time that that type of behavior would be acceptable. And so I did read the whole report. And I know this is a question, but I don't see where the difference of how much change could probably be in training. So you talked about the training. What type of training could change what his belief or what an officer should do a year ago versus now and moving forward? What type of training are we talking about?
Hector, can you discuss your de-escalation training? And then additionally, you had touched on the fact that you had since been confronted with other situations or similar situations and you had made alternative choices. Can you elaborate on that?
Yes, ma'am. So I attended multiple classes. The first one being a 8-hour force science decision-making course, and it talks about the science behind how fast you can perceive something, how fast you can react after you perceive what's going on. The fight or flight mentality, different options to utilize other than than force, right? You can use use your words to try to de-escalate the situation, and then it preaches on utilizing your tools, whether that's a taser, a baton, or any other less lethal pepper spray, and then utilizing the appropriate amount of force for the situation. But it also goes into, for somebody like me that didn't have that much experience at the time, it helps being in a classroom filled with officers that have been on for 5 years, 10 years, 15 years, because the course that I attended, that was just the part one. I went to a three-day advanced force science class, which is more for supervisors. And having all that experience, all that wealth of knowledge in that room helps somebody like me that didn't have that much time on at the time understand it from the eyes of a 20-year cop. And it helps open my eyes and broaden my perspective and approach things differently. Those classes were definitely beneficial, and I think I proved that in the year and a half that I was on patrol prior to my demotion, because I had no incidents when it came to use of force.
Yes.
Training, is that part of the curriculum? Because I'm thinking kind of forward. Okay. Part of that training is something he had to take after the incident. Is it part of the training in post?
So Mr. Marshall would probably be better to answer this, but de-escalation training is part of the regular basic course. So that would be something that respondent would have been trained in as part of his regular basic training before he even began his position as a police. But Mr. Marshall would be in a better position to answer fully.
So there are classes that sponsored by Post, continuing education throughout the officer's career, that there's numerous de-escalation, use of force training. Just because you took it in the academy maybe 20 years ago, an officer that wants to better himself will be taking training regularly. If it's not a department mandate, it is the officer's ability to go do the training on his own, either through Post or private instructors throughout.
Within the first year of leaving your basic post training, an officer would have had this?
He would have de-escalation training in the academy. It's possible during his FTO on the in-house training, they might cover something, and I'm not sure, every agency is specific. There are agencies out there where if the officer doesn't want to better himself, they're not going to complete much training through their career.
I will point out, just looking at, excuse me. Just looking at Mr. Victoria or Officer Victorio's EDI profile, that in addition to his basic course, he also took additional training courses after he became an officer. So he became a police officer on March 14th, 2022. In addition, he took an arrest and control, which would have included some of this. He also took use of force. That was on April 6th, 2022. He took additional training courses that would have included some of this stuff. And then after this incident, he took the de-escalation training in February 7th, but he also took things like special weapons and tactics courses on October 20th, 2023. So all of that would have included some elements of de-escalation in that, since any sort of use of force would have had some elements of de-escalation. So yes, there would have been some of that.
If I may, to answer the question in kind of more specific terms, Learning Domain 20 has 8 hours of de-escalation training in the basic academy. And then every 2 years thereafter, there's 4 hours of required de-escalation training.
Johnson.
I guess my question, when he crashed into the pole and you came out the car, I'd like to know if you've seen him laying face down, hands stretched out and not moving. So when you came out the car, did you see that or did you see something else?
No, sir. Like I said initially, when I first came out of the car, or prior to coming out of the car, I saw the door swing open. So my initial thought was that he was going to continue to flee on foot since he had crashed the vehicle. When I came around my door is when I realized he was on the ground. But that's not what I perceived at the time. At the time, I perceived he stumbled out of the car because he just got into a car accident and he's going to continue to flee. Like I said before, I understand that I was moving too fast, and I think that was my shortfall, my shortcoming here. If I would have just remained by my door, done a felony traffic stop, and slowed down and just taken in all information, I could have made a better decision at that point in time.
And the second part of my question is, so there was 6 punches and 4 knees. So when you realized that he was face down, hands stretched out, saying, "I'm not resisting," you still delivered 6 punches and 4 knees. Was that part of your training? Even though you have a victim that is not resisting, what caused those 6 punches to be thrown, in your view, and those knees to be given?
Yes, sir. So again, at that time, I perceived that he was resisting. You know, it's inexperience. There's no excuse to my actions. I perceived that he was resisting. You know, when I would strike him and he wouldn't bring his arms to his lower back, I perceived it as resisting at the time. Obviously, I didn't take into consideration that my blows were causing pain to him, you know, which is why probably he kept his hands above his head and not brought him down to his lower back in order for us to effect an arrest. At the time, I perceived he was resisting, but looking back at it now through all the training that I've received, I understand now that I could have done things differently.
Was that your first encounter physically?
Are you asking if that's like my first use of force?
Yes.
No, sir. I wouldn't be able to tell you how many I had prior to then, though.
Questions? Go ahead, Steve.
So, on the incident that we were just talking about, the November 27th, 2023 incident. So your reasoning for why that occurred was that you were acting too quickly. Is that what you're telling us?
That's not the only reason, but I mean, I think all that could have been avoided if I would have just slowed down.
Okay. And then on the second incident, when you made a threat to the person who was not resisting, was just standing by a wall, you say you made the threat because you were concerned he would run?
I didn't say I made a threat, ma'am. I made a statement that I understand that wasn't the best thing to make. He had just fled. There's 100%, 1,000 things I could have said that would have been better to prevent him from continue to flee because he had already done it once. But I understand that I was in the wrong and I accepted discipline for it.
Okay, because at that point, the situation had been de-escalated, right?
Yes, ma'am.
So you made mention of you had de-escalation training after that time.
No, so that incident happened before the November incident. It just the investigation came afterwards.
Okay.
Yes, ma'am.
Okay, because that situation had already been de-escalated when you made that remark, which I would consider threatening, but right?
Yes, ma'am.
Okay, thank you.
In watching the video, you said, in your statement just now, you said he had fled. And then I recall the gentleman stating that he was hard of hearing. Did you were in your police vehicle at the time?
Yes, ma'am. What you saw was just the ending of the entire interaction.
I get it. I got another part of my question. Did you turn your lights on? Did you use your speaker to try to gain his attention? Was he in front of you, on the side of you? Can you paint that picture for me?
Yes, ma'am, of course. So I was driving southbound. So let's just say I'm driving towards the monitor there, and he was on the sidewalk off to my right-hand side. I wasn't even dispatched to the call initially. I was on my way to the hospital to relieve one of my partners, but I was monitoring the radio, and I understood that there was an active burglary in progress and that there was two individuals outstanding. They broadcasted the description of one of them. As I'm driving southbound, I spot somebody who matches that description. I get out of my car, I park it, throw my lights on, stand by the driver's side door, and I yell out to him. He looks back in my direction. And then when I say, "Police, come here," he continues to drive away off of a scooter. And at that point is when I broadcasted it to my partners over the radio that I had one matching. And it's when my partner that was driving northbound was able to intercept him.
Okay. Is it normal practice to throw evidence in the trash?
No.
Is it normal practice not to log in evidence?
No, ma'am.
But in two of these cases, you did both. The one with the young lady and that you pulled over, asked, could you search her house? And then you found bullets. And then with this gentleman in his backpack.
Yes, ma'am. So for the first incident, which is the commercial burglary, I mentioned in my internal affairs interview that the reason why the backpack was disposed was because there's things that in there that we can't tag. And I also mentioned during that interview that the only thing that I knew at that point in time during that investigation was that the scooter was that he fled in was the victims from the commercial burglary. And the only reason I knew that was because the victim came onto the scene and identified that as a scooter. The victim never spoke to me directly because I wasn't the investigating officer. I understand that I should have spoken to the victim myself to see if any of the contents within the backpack belonged to him, but I didn't. And the reason that I threw away a lot of the stuff, which I mentioned during my interview, was because the backpack was soiled and we're not allowed to tag in soiled property. By soiled, I mean there was, I think there was like a buzz ball in there and it had leaked and a bunch with, hygiene products and stuff that we can't tag. The second one, I openly said during my interview that it was a mistake. I totally forgot to tag it. I didn't dispose of it. I had it when the interview was brought up. I mentioned it to Casey. She gave me guidance to hold on to it until the day of the interview, which is when I mentioned it to the investigators, and we tagged it into the property then.
Do you
Yes,
mind
ma'am.
if he addresses remediation that has taken place related to those two topics?
Yes, so in my new position as a community service officer and even the year and a half afterwards, I took a different approach to tagging in property or disposing of property, anything in relation to property or evidence. Instead of waiting towards the end of my shift and then tagging everything into property evidence, then I pretty much skipped that entire thing. And as long as time allowed and calls for service allowed, I would go straight to the police department and tag in the property or evidence at that point in time. That way, at the end of my shift, I wouldn't forget it. And I'm sorry if I, and pretty much to conclude on that topic, in my current position as a community service officer, I still do handle evidence and property on a day-to-day basis. I like, again, there hasn't been any issues as it comes to property or evidence in that aspect. Thank you.
Thank you.
Vice Chair Juggley, if I may address the record. So just to give a little bit more context as to that stop in October of 2023, when then Officer Victoriao pulled over that individual or attempted to pull over that individual, it was at a light rail station. There were several other individuals present. He did call out to that individual. However, like I said, there were several other individuals present. There was also announcements being made at the light rail station. So when the individual then says to the other officer present and then Officer Victoriao that, I'm hard of hearing and stuff like that, that is relevant to this incident. He is quite a few feet away. So if you see on the body worn camera footage, you can see that individual is quite a distance away. And so then Officer Victoriao is calling out to him, hey, you come here. And then that individual just keeps going on the scooter. And then respondent says to the other officer, who is the one who eventually ends up getting to the arrestee and putting him in cuffs, I'm going to go this way, you go this way, essentially. And then the other officer is the one who finds him. So that's how that ends up coming out, just to finish that up. And that is documented fully in the attachments for that incident. As to the other incident, for the destruction of the backpack, the statements, which again are further documented fully in the investigation, basically that backpack was, the Officer Victoriao did state that he destroyed the backpack because it was icky, that there was some sort of liquid that had been spilled. However, he did book another item into evidence, a shirt that the individual had over his shoulder that apparently he used to cover his face. So it wasn't just the scooter, there was a shirt as well. So it wasn't just the scooter that was thought of evidence. And there was some suspected narcotics that were found on that individual's person that was put in the backpack for safekeeping, but were never tested to see if there were narcotics.
Question.
Yeah.
Oh, on an incident, either or can fill it in for me. An incident where we stopped the individual, I don't know if it's a female or not, and I was confused about that part. And then somehow the officer goes to her home, search her home, and finds 4 bullets. I couldn't wrap my mind on, was there a stop that led to, from that place to going to her home? And what was the reasoning? I couldn't find it in a report of why.
He did conduct a legal vehicle stop on the Dodge Challenger.
It was a challenge.
Challenger. did conduct a legal stop, and then discovered she did not have a valid driver's license.
The whole,
He got consent from her. He'd probably be a better, but he had gotten consent to search her vehicle and then her home.
For you answer, in case you decide to, let me add to her question. Was she on searchable parole, probation, or any of those things that would have led you to just ask Jane Doe, can I go to your house and search it? I think that.
yeah, that's kind of where I'm going. I couldn't find it in the report.
No, I'm sorry. No, so every time I conduct a traffic stop, there's about a couple things that I ask. Hey, this is why I pulled you over. Are you on probation, parole? Have you ever been arrested? It's just kind of how I do my thing. She had told me that she had prior weapons violations in LA County. So then I had her step out of the car because her vehicle was suspended. And then I take a very proactive approach. Like I mentioned before, I recovered 30 firearms within 3 months. And that's kind of the approach that I had on that day. She told me that she had ammunition at her home. I asked her if I can search her residence, in which she said yes. I took the ammunition, and I waited till the end of my shift to tag it in, and that's where my mistake was.
But was she arrested or not?
Probation for driving without a license.
On probation or parole?
She was not on probation or parole.
So is that normal policy and procedure to ask individuals that you do a traffic stop on, whether you can search their home?
Well, it was a question, ma'am. She could have denied it. It's not.
Is it policy or procedure?
No, there's nothing asking, or there's nothing on policy stating whether I can ask somebody or not for consent.
To search their home for no reason? Just because you stop them for something else, and then that leads to you asking them. So if I walk outside today in West Sac PD, if West Sac PD pulls me over, if Chief Strange pulls Nicole Clavo over and says, I'm pulling you over because you were doing 75 and a 55. And by the way, can I search your home?
Again, ma'am, I asked that because she had told me that she had prior weapons violations, which is why I asked the question.
But she didn't have any weapons on her currently.
Correct.
Okay.
And there was nothing ran to verify that she did in fact have a probation or parole. Is there any way of doing it? Like I said, I read the report and that was a big dark hole for me.
So I conducted my own records check on her. Because her arrests were in LA County, it wouldn't show on our local hits. So I wouldn't, no, I did not receive a probation or parole screen when I ran her information.
Johnson.
Mr. Johnson?
Yes. What was the date of that incident?
That's April 28th, 2025.
Now, I had asked a question earlier about, was that your first physical incident? And you had stated no. So I'm curious to, when were the other physical incidents?
Are you talking about the pursuit, sir, that happened in 2023?
Yes, the pursuit on November 23rd, correct?
Yes, sir.
27th.
The
2023.
Oh, okay, 2023.
I'm sorry,
On
Board Member
Thanksgiving
Johnson,
Day.
the search was April 28th, 2025. The search or the use of force is November 27th, 2023.
Okay, 25, 23, and then the incidents where the young man was on the scooter was October 2023.
October 28th, 2023, correct.
Okay, but you were in other physical incidents. Were they prior to October 2023, or after October 2023?
Are you talking about from the time that I received training, or
From the time that you began patrolling?
So before the use of force incident that we're here for, I did have use of force incidents, but again, I wouldn't be able to tell you how many or when they took place.
You don't remember how many incidents you've been in?
No, sir.
Thank you.
I think I'm still stuck on the black hole.
Okay, one more question, Ms. Crawford, go ahead.
And I'm sorry. Again, I read it and read it and read it. And so would you say that although that's not a policy of San Bernardino, it's not a policy opposed to ask a person who you're not really sure is on probation or parole because you don't have access to the database of LA County other than what she tells you, to go to their home and search their home? And I understand that you said, you know, your career high is that you pulled over guns, attained guns and everything else. I'm just trying to understand, is that a pattern that you would normally do in one of your stops? Is to ask a person, are you on probation, parole? Then if they say yes or no, whether it's in that county or not in that county, then it asks to search your home. Is that a pattern?
No, I wouldn't say it's a pattern. I would say it's based off of the information that they provide to me and the information that I receive after running their name in our database. Again, I had a proactive approach, and my mentality was I'm going to get a gun off of the street today. And when she told me she had prior weapons violations and that she had ammunition at her house, then that's when I asked her. I was like, "Can I go back to your house and take the ammunition from you?" And she said yes.
And so there's no search warrant. She could just say yes and we can go do that.
If she agrees and gives consent.
Ms. Clara.
Just a point of clarification as an instructor of search and seizure, it's not illegal to make the ask.
Exactly.
My concerns grow out of, are you familiar, officer, with the concept of duress? And I can elaborate if you need me to.
If you could, please.
Okay, so generally speaking, consent, if it is to be given, has to be given freely and voluntarily, with no threats of enforcement or promises of leniency. And I believe, so now I will ask you, are you familiar with the concept of duress?
Yes, sir.
Do you believe this woman freely and voluntarily gave you permission to search her home?
I do.
Thank you.
Thank you very much.
Can I make a final?
Sure, briefly, please.
I understand that these incidents that have additionally been presented to the board for review and understanding are significant, and I appreciate your thoughtful questions. I do want to reiterate that Officer Victoriao has taken affirmative steps to continue to grow in search and seizure, to continue to grow in de-escalation training. And the matter that we're here before the board for, the allegation related to physical abuse and excessive force, is taken very seriously by Officer Vic. Would ask that although there have been missteps in his young career, we feel that this is one of those instances where an alternative to revocation would be appropriate.
Thank you.
Thank you.
Thank you.
Is there anybody from the public who would like to address? What? Is there anybody from the public who would like to address the board at this time? Yes? You may state your name and organization if you wish. You will be given 3 minutes to speak, and the time limits will be strictly enforced, so please ensure that you complete your comments within the allotted time.
Okay, I am Beatrice Johnson. Since I'm the only community person here, I feel like I do need to say something. Good afternoon. My name is Beatrice Johnson. I'm here again because what I witnessed in this case is deeply disturbing to me. not just a community member, but as someone who has spent years advocating for accountability, and also with this bill, Senate 2, law so that officers who abuse their authority can be decertified. We watched the video. We saw the suspect exit from the vehicle after crashing, lay on the ground, and say that he surrendered. At that point, there was no threat. There was no active threat. There was compliance. The suspect was defenseless. But despite that, the officer chose to act on what he perceived instead of what was clearly happening in front of him, reality. And that is where this becomes dangerous. Because when perception overrules reality, especially in policing, people get hurt. The officer immediately began kicking and punching the suspect while yelling, "Stop resisting," even though the suspect was already on the ground, surrendering and defenseless. That disturbs me deeply. We have seen this pattern before where the words stop resisting are used to justify force, even when compliance is visible. And too often, those words are spoken right before someone loses their life. That is not just a phrase, it is a warning sign. When an officer continues to use force on someone who has already surrendered and is defenseless, that is not policing, that is punishment. And what is equally concerning is what we are hearing here today. The officer and his attorney have made light of this, in my opinion. This is a problem because when a serious conduct is minimized instead of acknowledged, it shows a lack of accountability. And where there is no accountability, there is no reason to believe the behavior will change. It is also deeply concerning that the officer told the suspect, you know what he said, the bad word, lucky people are around, or I would do something else to you. That is not law enforcement language. That is not de-escalation. That is not professionalism. That is a statement of intent. Hold back only by witness. And that should concern everyone. This is exactly why Senate Bill 2 exists. For situations where an officer demonstrates conduct that is excessive, dangerous, and it should be held accountable, and he should be decertified because that's how people get killed.
Thank you.
Thank you.
Is there anyone else from the public that wishes to address the board? Okay. At this time, does the board want to adjourn into private session?
Yes,
Okay.
please.
All right. Meeting will be adjourned until and we'll go into closed session for deliberation. Will be back shortly. to take a vote on the board's recommendation in the matter of case post 2322062, Hector Victorio. Is there a motion?
I make a motion to decertify.
Is there a second?
Second.
We have a motion by Johnson, and a second by Clavo. Roll call?
Clavo,
Aye.
Clavo, I Crawford,
Aye.
Crawford, I Doyle,
Aye.
Doyle, I Johnson,
Aye.
Johnson, I Lara,
Aye.
Lara, I and Pena.
Aye.
Pena, I, all in favor.
Motion passes. Okay, thank you. Next item, post 2302397, Armando Vina, last employing agency, Los Angeles Police Department.
No.
Okay. This time I'll call upon law enforcement consultant David Cyber and Brian Hoffman, attorney with Legal Affairs Bureau, to provide the report on case post 2302397, Armando Avina, who at the time was employed by Los Angeles Police Department. Cyber?
Good afternoon, Chair and members of the board. My name is Dave Sieber, and I'm one of the law enforcement consultants assigned to the Post Professional Conduct Southern Bureau, the Peace Officers Standard Accountability Division. With me today is Brian Hoffman, an attorney with our Legal Affairs Bureau. I'm here today to present post case number 2302397 involving former Los Angeles Police Department officer Armando Avena, whom I will refer to as the respondent throughout the remainder of this. Evidence exists to demonstrate that respondent committed acts of serious misconduct as set forth in California Penal Code Section 13510.8 on February 13th, 2022. Specifically, the division has determined that the respondent committed the following acts of serious misconduct. California Penal Code Section 13510.8 B6. Acts that violate the law and are sufficiently egregious or repeated as to be inconsistent with the peace officer's obligation to uphold the law or respect the rights of members of the public as determined by the commission. In this presentation, I will present a brief outline of the division's findings regarding this matter, starting with the respondent's background, followed by his prior discipline and the factual basis for seeking suspension or revocation of the respondent's peace officer certification. I'll start with the respondent's background. Respondent started his career with the Los Angeles Police Department on February 21, 2017. On August 6, 2017, the respondent was promoted to the position of police officer. This position is a peace officer as defined under Penal Code Section 830.1A. The respondent earned a post-basic certificate on June 28, 2019. Prior discipline. A review of the respondent's Los Angeles Police Department personnel file identified 4 non-categorical uses of force incidents, all of which were found to be in policy, and 2 vehicle pursuits which were in a pending status when he resigned from the department. The respondent was not involved in any categorical uses of force, vehicle collisions, or civil litigation while employed by the Los Angeles Police Department. Other than the captioned domestic violence matter, the respondent was involved in 1 additional post-allegation of serious misconduct. That is post case number 2321703. In that matter, the respondent, while off duty, was arrested on December 11, 2022 for a violation of California Penal Code Section 647F, public intoxication. This incident occurred after the captioned February 13, 2022 domestic violence incident, but prior to his resignation from the police department, from the LAPD. A subsequent LAPD personal complaint investigation into the December 11, 2022 incident sustained allegations that the respondent was intoxicated in public while off duty and that he failed to cooperate with Pasadena Police Department officers, noting that the respondent chose to drink past the point where he was still in control. The respondent was not criminally charged as a result of this arrest and ultimately received a 2-day suspension with a loss of pay and benefits. Now I will go on to provide a factual basis for the investigation. On February 12, 2022, while off duty, the respondent and the victim, who he was in a qualifying relationship with, went out for dinner and drinks. After eating dinner at a restaurant, they stopped at a brewery for several beers before proceeding to a lounge in Whittier, California. While inside the lounge, the respondent observed the victim speaking with another male patron, which caused him to become upset. The respondent confronted the victim about speaking with the individual and questioned her about purchasing 4 shots of alcohol. The respondent's demeanor became increasingly aggressive, and the two returned to their table where the verbal argument continued. Although they ultimately agreed to leave the lounge together, both consumed the previously purchased 4 shots of alcohol before the respondent drove them home. Upon arriving at home, the respondent gained access to the victim's cell phone, and the verbal argument over claims of infidelity escalated into a physical incident. The respondent pulled the victim's hair, dragged her into the bathroom, forced her into a bathtub while showering her with cold water. The respondent refused to let the victim out of the bathtub and punched her in the face with closed fists, scratched, slapped, and choked her with both hands, caused a concussion, visible bruising to her face, chipped front teeth, a split lip, a sore neck and back, and scratches to her arms. Later, on the morning of February 13, 2022, after the respondent and the victim awoke, the victim asked to be driven to her family member's residence. The victim stated in her recorded interview that the respondent replied, "No, I don't want you to leave. Like, can you please, if I take you, tell them I didn't do anything to you. Like it was a knee, like I'm sorry." Nevertheless, the respondent reluctantly drove her to the family member's residence. Upon arrival, the victim's family member observed the victim's injuries and immediately called the respondent, demanding that he return himself in. The respondent hung up, at which point the victim's family member notified the Baldwin Park Police Department. The victim was subsequently transported to the Kaiser Permanente's Baldwin Park Medical Center, where she received medical attention for a headache, neck and back pain, bruising and swelling to her face and left eye, bruising to her hands, a split lip, chipped front teeth, and broken fingernails. Kaiser Permanente ordered CT scans of the victim's cervical spine, facial bones, and head, along with x-rays of her hands, ribs, and chest, scapula, and wrist. Ultimately, the victim was diagnosed with a shoulder contusion, multiple soft tissue contusions, a subconjunctival hemorrhage from a broken blood vessel in her left eye, and a concussion with a loss of consciousness. Contemporaneously, Baldwin Park Police Department investigators obtained an emergency protective order for the victim and arrested the respondent for a violation of California Penal Code Section 2273.5A, domestic violence. Baldwin Park Police Department presented the criminal case to the Los Angeles District Attorney's Office for review. Upon evaluation, the District Attorney's Office filed 1 count of California Penal Code Section 273.5A, misdemeanor domestic violence. Los Angeles Police Department also initiated a personnel complaint investigation on the respondent. As part of the complaint investigation, Los Angeles Police Department detectives interviewed the victim on February 13, 2022, after she was discharged from the hospital. The victim alleged this was not the first instance of domestic violence involving the respondent. The victim stated that sometime in January of 2022, the respondent, while off duty, broke her eyeglasses and cell phone, forcibly pulled her hair, and threatened to kill her. The victim also alleged on October 24, 2020, while off duty, the respondent threw a folding table at her, nearly striking her and requiring a domestic violence response from the Baldwin Park Police Department. The victim emphasized that she just didn't want to see the respondent any longer. Photographs and medical records taken less than 24 hours after the February 13, 2022 incident confirmed the victim's statements that she sustained injuries during the physical altercation. On February 15, 2022, LAPD detectives interviewed the respondent. The respondent denied physically assaulting the victim, stated that he unintentionally struck the victim with his elbow when he twisted his torso to stop the victim from taking her phone away from him. The respondent believed this action caused the victim to fall into an entry table. However, he was unsure if the victim hit her head on the table. The respondent also stated that the victim jumped on him while he was on their bed, again attempting to grab her phone from him. The respondent went on to explain that the victim fell on the carpeted floor, and the respondent denied hitting, punching, pulling her hair, choking her, or slapping the victim or threatening to kill her. The respondent declined several attempts by the division to conduct follow-up interviews. The LAPD's complaint investigation ultimately sustained 7 allegations of misconduct and directed the respondent to a board of rights with a recommendation of termination. On April 12, 2023, the respondent pled no contest to 1 count of California Penal Code Section 243E1, misdemeanor domestic battery, arising from the February 13, 2022 domestic violence incident. As a result of this conviction, the respondent was placed on formal probation in Los Angeles County for a period of 3 years and is subject to a criminal protective order in favor of the victim until April 12, 2028. On April 30th, 2023, 18 days after entering a plea of no contest, and prior to his Board of Rights hearing for termination arising from the February 13, 2022 domestic violence incident, the respondent resigned from the Los Angeles Police Department. I'd like to cover some communications that the division engaged in with the victim. On January 5, 2026, the division spoke with the victim regarding her allegations of domestic violence. The victim stated that the respondent had a volatile personality, which was exacerbated when he consumed alcohol. She stated that in October of 2020, when the respondent had been drinking, he grew angry and threw a folding table at her. The table did not hit her, but she feared for her safety and called the Baldwin Park Police Department. When they responded, the respondent was asleep in his room with his firearm nearby. The victim left their residence and stayed with a family member for the remainder of that evening. The Baldwin Park Police Department confirmed the victim's call for service and response, but did not file a report documenting the incident. The victim also clarified prior statements regarding the domestic violence she suffered in February 13, 2022. Specifically, the victim described the nature of her injuries and the manner in which they were sustained. She reported that the respondent punched her several times in the face with closed fists while she was pinned against their bathtub, resulting in a concussion, facial bruising, a split lip, and chipped teeth, in addition to the injuries documented in the Kaiser Permanente's after-visit medical summary. The victim further stated that she believed the respondent intentionally showered her with cold water because he feared that he may have rendered her unconscious. I'd like to touch on the respondent's rehabilitation efforts. On April 12, 2023, the respondent pled to 1 count of Penal Code Section 243E1, misdemeanor domestic battery. His conviction resulted in a 3-year term of formal probation, 8 hours of community service, the required completion of 52 domestic violence training classes, and adherence to a criminal protective order for 5 years. Los Angeles County Superior Court records indicate that as of June 11, 2024, the respondent had completed all 52 court-ordered domestic violence training sessions. Firearm and ammunition prohibition. So under Penal Code Section 29805, a conviction for California Penal Code Section 243E1 automatically triggers a ban on owning, purchasing, possessing, or receiving a firearm or ammunition for 10 years from the date of the conviction. Under federal law, specifically Title 18 U.S. Section Code 922G8, a conviction of misdemeanor crime of domestic violence prohibits the possession or receipt of any firearm or ammunition indefinitely, so long as the conviction qualifies under the statute. On October 22, 2025, during an informal telephone conversation with the division, the respondent reported that he no longer worked in the law enforcement profession and was currently pursuing a career as a truck driver. Additionally, the evidence demonstrates that the respondent's conduct was egregious, as reflected in the victim's post-incident medical records and repeated as documented in the victim's post-incident interview statements. Ultimately, the respondent's actions reflected adversely on the Los Angeles Police Department and the law enforcement profession. Failure to take action could create the perception that domestic violence is not taken seriously, thereby eroding public trust and confidence in law enforcement. The facts I've just recited support the division's finding that the respondent was involved in serious misconduct, specifically Penal Code Section 13510.8B6. For purposes of the division's analysis, clear and convincing evidence means evidence of a charge is clear and convincing so long as there is a high probability that the charge is true. The evidence need not establish a fact beyond a reasonable doubt. The division recommends revocation or suspension of the respondent's post-certifications based on the following. Following a comprehensive review of the Baldwin Park Police Department's criminal investigation, the Los Angeles Police Department's personal complaint investigation, the respondent's department personnel records, the respondent's statements, the victim's statements, and witness statements, Los Angeles County Superior Court records, and other supporting documents, the division concludes that clear and convincing evidence exists to establish that the respondent committed serious misconduct under California Penal Code Section 13510.8 B6, acts that violate the law. Specifically, the evidence demonstrates that the respondent's actions were sufficiently egregious when he assaulted the victim, causing significant physical injuries, including a concussion, subconjunctival hemorrhage, chipped teeth, a split lip, broken nails, and bruising to her face, neck, and back. The respondent's actions are inconsistent with an officer's obligation to uphold the law and therefore violate Penal Code Section 13510.8 B6 and Commission Regulation 1205A6 when he committed and was convicted of a misdemeanor violation of Penal Code Section 243 E1, domestic battery. Additionally, the respondent's domestic violence conviction triggered a 10-year California state prohibition on the possession of firearms and ammunition. Further, the respondent's misconduct on February 13, 2022 was not an isolated occurrence. The records reflect a pattern of poor judgment, emotional volatility, physical violence, and irresponsible alcohol consumption dating back to at least October of 2020. Based on its investigation and the consideration of the factors enumerated in Title 11, California Code of Regulations 1213A, the Peace Officer Standards and Accountability Division has determined that the respondent's conduct was egregious and repeated, demonstrating a disregard for public safety and was inconsistent with the responsibilities of a peace officer. Accordingly, the division concludes that reasonable grounds exist to seek the suspension or revocation of the respondent's peace officer certification pursuant to California Penal Code Section 13510.8. With that, I'd like to present the board with some redacted images of the victim's injuries. The unredacted images have been provided to the board members. With that, I'm happy to answer any questions the board may have. Thank you.
Just before we proceed further, my colleague, Mr. Sieber, received a text message communication from the respondent earlier this afternoon indicating that he would like to proceed probably with the voluntary surrender process. He has not done so yet, so we need to continue forward with this, but we wanted to provide that communication to you as well since we received it earlier this afternoon.
Board, questions of staff? Okay. Is there anyone from the public who would like to address the board at this time? Seeing. At this time, does the board wish to adjourn in private session? Closed session for deliberations? No? Okay. And we will. Someone would like to make a motion?
Is there anybody on the phone?
No, their officers council is not present today. There was a public comment included in your materials from Officer Vino.
I make a motion to decertify.
Okay, there's a motion by Crawford. Is there a second?
A second.
Second by Laura.
Clavo.
Aye.
Clavo, aye. Crawford.
Aye.
Crawford, aye. Doyle.
Aye.
Doyle, aye. Johnson.
Aye.
Johnson, aye. Laura.
Aye.
Laura, aye. And Pena.
Aye.
Pena, aye. All in favor.
This was the last item on the agenda. Do any of the board members have additional comments before we adjourn? Seeing none. Is there a motion to adjourn? We have a motion, a second?
I second it.
Okay. All those in favor say aye.
Aye.
Okay. Meeting adjourned.